Good morning. Good morning. It is Thursday. It's November 7th. We're going to court today in Idaho. I honestly put this on the calendar so long ago because this case has been going on for so long that I forgot that it was happening today. So when I said we were doing food court today, not food court today, we were going to do music court today. But court in Idaho is going to be a very full day of court in Idaho. And I wanted to cover that with you. Live court is like, we've got you this week. Let's just all go to live court together and just see what court is doing. And I appreciate it. The judge is not on the bench yet. The judge put out the most detailed, this is the order we're going in. This is how much time I'm giving you. Judge H is like, we're not going to talk in circles. I read your briefing. I imagine what we're going to see from Judge H today is like what we saw from the appellate court. Tell me the main point. Do not just come here and verbally reiterate your filed motions. You filed them. I read them. I looked at the case law. I'm going to ask you questions. You're going to answer the questions. We're going to do the things. So here's what's on the docket today. The state in this case filed all of their notices of intent to seek the death penalty if Bryan Kohberger is convicted when he goes to trial at the end of August 2025, a trial that's expected to last through November of 2025. Of course, the penalty phase doesn't even come into play until he is until he is convicted. If he is not convicted, the penalty phase does not come into play at all. So we will have to see what happens. There are lots of legal motions that need to happen here. One of the things I appreciate about Ann Taylor is her excellence in preciseness in language. She always refers to the guilt phase of the trial, which is what most lawyers call it, as the innocence phase, because even in her language to the court, she is not giving an inch of saying that her client is guilty. It is always once we get past the innocence phase, if we get to the sentencing phase, which a lot of lawyers call the punishment or penalty phase. So you will hear me use those interchangeably. I really appreciate that from Ann Taylor, but I also default to the language I've always used, which is guilt phase and penalty phase. So the penalty phase is when a jury, the same jury that decides guilt, will decide what the punishment should be. In some cases, you will see that sometimes guilt will be established by plea deal or what have you, and things will just go to trial on the penalty phase. That's not what's going to happen here, but the motions today are all regarding the penalty phase. For some of those motions, the prosecution has said these are things that are way too early to determine. This is premature. This is too soon. This hasn't even come up. We don't need to do the rest of this. But these are the things on the docket today. Before we saw anything happen in court, the judge had a closed door hearing about the street close motion. The court was not 100 on the fact that Bryan Kohberger would or would not be allowed to wear street clothes in court. That motion was heard earlier. We'll see if we get any glean of what happened there. Then we've got some objections to the defense's experts. Those experts go to the manner of execution. The prosecution says, hey, this is all way too early. Those can be post-conviction motions or even post-sentencing motions if we need to get there. There are also a ton of motions to strike. Those motions to strike are the aggravators. There are motions for disclosure. So when we're looking at aggravators, there are things that make a murder eligible for the death penalty in any given state because the states get to choose if they have that as a form of punishment. I think we'll hear some defense arguments that this should not be the case in Idaho. The judge is going to say, talk to the legislature. I am the judge. I impose the laws that the legislature writes. If the legislature changes the law, I will enforce that law as well. But those arguments are going to continue to be made in court by Ann Taylor and probably every other death penalty defense attorney across the country. So the aggravators are felony murder, future dangerousness, multiple victim, and then there is the, you'll hear them calling it the HAC today in court, but it is the fact that if it is shown that the crime is heinous, atrocious, or cruel, manifesting, why is that hard to say? Emily, can we manifest? Not right now. Manifesting exceptional depravity, then there can also be the aggravator for that. So those aggravators are things that bump up not just the crime into death penalty categories, but also can bump up the consideration by the jury. So the jury will be allowed to consider these things if they get to punishment. Then we also are going to have them talking about trifurcating the proceedings, like pulling them apart and doing them separately, and then a motion to strike based on speedy trial. When I said there is so much going on today, those are all separate motions that we'll hear. The court will probably lump them together. So for some of you are saying court is streaming now. Yes, we are giving a little bit of a delay because we wanted to be able to put closed captioning on court. So we are going to be streaming court ourselves. Thank you, Team Baker, for setting it up because we wanted to be able to put closed captioning on the court proceeding. And we didn't want to get cut off if we left Zoom room or I paused to explain. So we're giving it just a moment so that we can have closed captioning. I figured that for us, closed captioning helps me stay focused and pay attention, but I know a lot of our law nerds also can use it, especially if I say something over someone speaking, then you have both me and the closed captioning. So with that, I also wanted to remind you that we are closing Law Nerd Shop 1.0 tomorrow. So if you have not gone to the Law Nerd Shop, yes, we have a Law Nerd Shop. If you have not gone to the Law Nerd Shop, we have a few of our bundled tumblers left. They are 2 for the price of 1. So if you want your Law Nerd tumblers, you can get those today. There are just a few bundles left, so make sure you go grab those because then they are going away forever. And then the Law Nerd Shop is closing. If there is something in there that you love, make sure you go get it. We have a Law Nerd Shop 2.0 coming with custom created goods, especially for the Law Nerds, but we are changing our sourcing, our distribution, so we have more control. We'll just do it ourselves. So we have more control. And in those initial launches, your favorites that might be in the store now are going to be reimagined. So if you do not have a fax hat yet and you love it, get the fax hat. It's not going to be relaunched for a little bit. If there's a mug you want, get it. It's not going to be relaunched in the first launch. The first launch is all new, all custom for you. So that is what we have together in the Law Nerd Shop. So don't forget to check out the Law Nerd Shop if there is stuff that you still want, or if you are waiting for Law Nerd Shop 2.0 to drop later this month, I appreciate it. We're going to be making sure that our ship times get to you before the holidays. With all of that, it is time for us to go to court to see what's going on in Idaho. We do have a stream sponsor, so we will take a break in a little bit for our stream sponsor. Our stream sponsors, not just the Law Nerd Shop, but allow us to not put mid-rolls every 30 seconds in the court hearings, which I hate doing. We are not going to pop up ads and QR codes on the bottom of the stream for the entire stream. I hate that. So our sponsors allow us to be fan-funded and cover the topics that we want. And then if we cover court and court gets demonetized, we're good, because sometimes it does, because people say things in court that are wild, Liz said, are we going to get Zoom shirts? I mean, we should, but I wonder if Mazda would have an issue. So, we're going to make sure that everybody's intellectual property is fine, because I'm sure they have some of that. But we're going to go to court in just a moment. Let's roll the intro. Let's get started. You guys are law nerds. You know what we're doing. You know what we're here for. Today, we're just going to talk about these hearings. I know that this form of punishment comes with a lot of conversations. While states still have this punishment, it is up to the people in that state to choose whether it is right for them. Ann Taylor's going to make some of those arguments today. The judges have to follow the law. Legislature writes the law. So we will see what happens, but different states have been removing that from the states. So we will see what happens. For the Canadian law nerds, I am sorry. Canada changed a bunch of the tariffs coming into Canada. And so the tumblers are the one thing right now that is not available in Canada because of the tariffs. We didn't want the law nerds to be surprised by the amount of tariffs, and the amount of taxes coming in. They were so high. So they are one of those things. When I was looking at it, I'm like, I can't ask the law nerds for these, it was averaging over $60 to ship them into Canada. That I was like, this is way too much. And I know some of you still want them, but I can't ask you to pay that. And unfortunately, at this point, we can't either, but we are changing where we source our goods from and our distribution to avoid that in the future. So we are actively working so this is not a problem going forward. And so I apologize, Canadian law nerds. No, CeeLo, not $60 for shipping. No, shipping plus tariffs of upwards of $60. So it's upwards of $60. So that is difficult. So with the things that we are creating, the tumblers were the only thing that was an issue, which is why they can't ship there. But as we move forward, we have changed our distribution and sourcing, so it's not a problem. So Canadians, I'm sorry, but I couldn't even ask, and I didn't want anyone to be surprised. So we as a team discussed it and made the decision that even if some were like, no, I'll totally pay $100 plus for a tumbler, we're like, no, we're not doing that. So don't worry. We've got new things coming, and we've got some. I can't wait. I can't wait. If we start now, we're never, ever going to get to court, because I'm so excited about what we've created for you. And I'm just so excited. I'm so excited. But we're going to go to court because I'm excited for that too. I'm glad to be here. I'm glad to be here with you. And look, it's a week I want to be in community. You want to be in community. We're going to all be in community together and just look at lawyers doing court and watch a new judge in this case who definitely, do you guys remember the first day of this case when this judge sat down and was like, I would love to say I'm happy to be here, but we're not going to start off with an untruth? That judge. Yeah, I'm excited to see what's going on with him today. I think we're going to see a much more streamlined court process.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not. Let's get into it.
All right, let's go to court, law nerds. Let's hope that volume sounds good. I think we can gain that up a little more. Bryan Kohberger's there in street clothes, so at least for today, that's happening. All right, Your Honor, hold on. We're going to back you up just a second because you're going to be sassy.
Now in session, the Honorable Judge Speedy, if we're presiding.
Well, the door was loud. Does it seem like he's happy to be there? He sits down, he's like, yeah, no. All right, this is just.
All right, we are back
there we go.
on the record in Ada County case CR 0124316665.
No one's been less happy.
Counsel are present.
No one's been less happy than this judge.
Mr. Logston.
Mr. Logston is
That's correct, Your Honor.
appearing remotely, isn't he?
And counsel previously identified for the state are present as well. Is Mr. Thompson going to be on the? Okay.
Oh, Santa's
All
not
right,
there,
So Mr. Thompson is appearing remotely.
which means he's not arguing.
This is the time set for a number of hearings this morning. Yesterday afternoon, I issued an order by which the proceedings would be handled,
gotta
the
be
order
honest.
in which that they would be handled, as well as designating the amount of time, generally speaking, that the parties or that the court will devote to the issue.
I loved that order. It was so organized.
The court has received extensive briefing by both parties and has reviewed it all thoroughly. So
Don't get up here repeating yourself.
first thing I want to address, just because the public was not here this morning, I did hear information from security
Though Judge H seems annoyed as all get out, like his whole vibe is, I'm not mad, I'm just disappointed. Like, I don't even want to be here today. I'm wondering if we're going to end up with him being like full, like, I wasn't even supposed to be here today. Somebody assigned him this case and he is hating it. But what I do appreciate is that he is very much looping the public in. And we've not seen that with the other judge. It's like, there was a closed door hearing. I'm going to tell you what happened that I can. And this is how I expect my courtroom to run. Do not waste everyone's time. We're getting to the point and we're moving on. I appreciate the judicial economy.
Security and from Ada County Transport regarding security measures that would need to be taken had the court allowed Mr. Kohberger to appear in civilian clothes. The state did not object to Mr. Kohberger appearing with civilian clothes. The court has employed security measures and is comfortable in terms of the security and flight risk related to Mr. Kohberger with those measures, and therefore has granted the defense motion to allow him to appear in civilian clothes.
I appreciate the court looping everybody in. The reason that was sealed to the public is because largely what they were discussing was security measures. And I'm not surprised that the court is mindful of the security of the courtroom, but also in a case like this, they are mindful of the security of Bryan Kohberger. So if they are talking about him being transported to and from custody, how he's going to get changed when and where, they want to make sure that that is not public information. It's really nice that he's able to say, we discussed security measures. That doesn't need to be in the public, but now the public knows what happened. And I appreciate him not being upset with the public interest in this case, which at times I felt Judge was like, why do you all want to know anyway? I appreciate that from this judge. I hope it holds, honestly.
The first matter we have to take up this morning is the objection to the testimony of
I'm just going to make myself fit into my own little Zoom box over here.
Barbara Wolf related to the method of execution. So let's proceed with that. The state can be heard.
The state's arguing that this is too early to hear this.
Podium, please.
Oh, are their heads are going to get cut off? Maybe, maybe not. Oh, look at how easy that
Our
is.
objection on this witness is really just the ripeness issue. We think that this claim is quite clearly several decades early at this point in time, and that's assuming that there's a conviction and imposition of the death penalty. And so we're just trying to save everyone time and would ask that the court find this issue is not ripe before we have an evidentiary hearing on it.
All right.
That's the extent of the objection.
All right. Thank you.
It's a fair argument. It's like,
Ms. Taylor?
why waste our time addressing something that's not even at issue to address
Thank you, Your Honor.
unless you lose the argument?
Your Honor, Dr. Wolf's proposed testimony is important for the court to hear and to think about the larger issue, and that is Idaho's inability to execute somebody at the given time. And there's a constitutional issue with having somebody sit on death row when there's no meaningful way for them to be executed. And Dr. Wolf's testimony will highlight for the court some information that may come up if Mr. Kohberger's ever convicted, and if there's a death penalty, and if he faces
Isn't that the time to
firing
address it
squad
then?
is one of the
Well,
options.
I also am not particularly convinced about your, well, I'm going to save that till we get to the merits. Let's talk about whether we need to hear from Dr. Wolf first. So I go continue.
Your Honor, I think that Dr. Wolf's testimony would provide the court with information about conscious pain and suffering, awareness of that pain and suffering,
I think
which matters for the Eighth
it
Amendment,
is a bit premature.
as well as why that information is known by her now. It's more recent information. It's after Idaho's history of having the firing squad and then removing it in light of the Bayes decision, and then in 2023,
Okay, but
instituting it again. But
you
this
could talk-
information
if
about
he's-
consciousness of pain and suffering happens.
I mean, if he's convicted, if he is sentenced, then it is time to argue it. His appellate rights would take decades to run. So I understand the argument that this is a bit too early to hear. She wants it on the record. I think it's too early. I'm not unpersuaded, but again, if you're going to say anything about Ann Taylor, I think the first thing that is going to be said is she is a vigorous advocate for her client and is going to overturn any stone that can be argued and do that.
In that window between 2009 and 2023. And I think the court should consider that and have that information. We also need to make a record in the event that there was ever a conviction in this case.
Thank you.
Okay, well, you raised it. I think the court's going to make them move on.
Very briefly, Your Honor.
A lot of you chatter like it's way too
I
early
would
to talk
just
about
note
this
that
now.
the defense did submit an affidavit. The court can review that. It clearly indicates what she would testify to if the court were to allow her to testify. So we don't really need to make a record because it already exists in the form of that affidavit. Thank you.
Oh,
All right, thank you.
this attorney, did you see what this attorney did? He spoke this judge's love language. Your Honor, it's already part of the record. We don't need to spend 40 minutes on this. It's already part of the record. You've already got the information. We can't decide this now. It's way too early, but you already know. So the record's protected. She made the objection, record's protected. This needs to happen a different day. I don't know if we've seen this prosecutor argue. I'm not surprised that the prosecutor's office has somebody that handles these motions. These motions aren't unique. When you've got a DP case, you're going to see similar DP motions. So what's coming, and there are generally attorneys that do more of these than others. So they end up being the expert. It's like, oh, you've done that twice. You're the expert for the office now. Good luck.
All right. The court is, having reviewed the materials, believes that given the concerns about the current justiciability of or ripeness, if you will, of the issue, I do believe that the declaration is a sufficient proffer of what that general testimony would be.
They're not testifying
That would
today.
allow us to discuss the issue. And so for the time being, I'm not going to hear from Ms. Wolf, or Dr. Wolf, I should say, her testimony. The declaration is an appropriate proffer. I will hear the merits of the motion based upon that proffer next.
Okay.
All right.
The court's like, right,
let's,
it's not ripe,
Hear that.
but we also have the
from,
proffer.
The defense.
Let's move on
Thank
quickly.
you, Your Honor. I would ask the court for leave to supplement that declaration. The information that is more recent between 2010 studies and a book that was published that is relied upon by Dr. Wolf,
That could have been
that's not
done, though.
contained in the declaration. And I would like to make that part of the record too from her. So if the court continues to have her testimony not be allowed, I would ask that I be allowed after the fact to make that part of the record.
You can submit that, and I will then hear any objections to that, and I will consider that.
Okay. Thank you, Your Honor.
Yeah, the
Then
court's like,
moving on to our
it's in the
argument, and
record.
I will largely not repeat what's in our brief since the court has had a chance to take a look at that.
ding, ding, ding. This
we
is
think that-
this is a whole different courtroom than Judge. This judge is like, I've read it. You've written it. We've considered it. And this is early. This is not the last time that these attorneys will get to argue this if the defendant is convicted and if he is sentenced to death. This is not the last time that they will get to bring this up. So he's not forestalling anything.
The court ought to strike the death penalty in this case and not allow the case to go forward as a death penalty case because Idaho does not have a current means of executing anybody.
And that's a fair argument.
When somebody sits
One of their
on
many
death
arguments to
row
strike.
and there's no real means of executing them, that is dehumanizing to that person. That's similar.
Say there's no means under Idaho law, the method of execution
it's
is
gonna be more like the
lethal
appellate court.
ejection, and if unavailable, then the firing squad. You rely significantly on the idea that lethal injection is not available based upon the quote unquote botched execution of Mr. Creech. It seems to me that was a particularized incident wherein Mr. Creech The execution really hadn't even begun yet, in the sense that they couldn't locate a vein. I don't see how that issue is universal.
Your Honor, I would agree that Mr. Creech's, the situation that happened to him was unique to him. I don't think he's the only person that has ever had that happen. I'm not in the state of Idaho, but I think that that's happened before when the means of execution couldn't be employed at the time. But since we're talking about Idaho, I think we should look at what happened in the Pizzuto case too. And in that case, there was no ability to obtain the chemicals to kill him with. And so his execution, his death warrant expired without him being executed. After that happened, Idaho passed legislation that would allow the Department of Corrections to obtain the chemicals to kill somebody in secrecy. After that happened, there's still a lot of difficulty getting the chemicals because pharmaceutical companies don't like to have
They
their,
have obtained them twice now, since then.
they've obtained them twice for Creech, yes. Now, something has changed in the death chamber for how they will try to execute Creech. I don't know what that is. That's probably one of those things that we'll learn a little bit more about through Creech's.
Well, I think that they're going to utilize a central venous catheter. In other words, accessing a central vein rather than a peripheral vein. My understanding that there's federal law approving that procedure, as well as a recent decision by the district court approving that procedure. I think that's the difference.
And I think, looking forward, we just don't have those answers yet. We don't know how that's going to unfold. I don't.
But you
believe his
also don't know if he's
execution is
going to be
moving forward
convicted.
as is scheduled. And if we look at the immediate history in Idaho, and that's what I'm looking at when I'm standing before you representing Mr. Kohberger and saying to you that Idaho doesn't have a real means of executing someone. The firing squad ended up on the books because of the difficulty obtaining the drugs to kill somebody. That's why the firing squad came back. The history of the firing squad, which is really well written by Mr. Logston in our briefing, is that it sat on Idaho's books for years. And in 2009, it came off in light of the Bays decision. When you think about it coming off in light of the Bays decision, and you look at what's happened since the Bays decision, and we're going to talk about that a little bit later today when we're talking about evolving standards of decency, we'll talk about
Which is
how
another
things
motion
have changed
she's
in
going to
this
bring.
country since then. But for these purposes, when you look at that and you realize Idaho brings it back in 2023, they bring it back because it's not reliable to believe that they're always going to be able to get the chemicals to execute somebody. And that's the real problem here. The firing squad hasn't been funded well enough to be built.
I think they're building it right now, as I recall, from the media at least. That
Really?
Construction's actually underway, but I may be wrong about that.
Okay.
Well, I haven't talked to the director of the Department of Corrections, and that's probably who I would take my word from if that's actually happening right now. I think there's some additional problems with the firing squad, though. I think there's some problems with the way our statute lays it out, too. If you read our statute, and the court just summarized it, it's lethal injection unless it's not available, and then it's going to be the firing squad. But the way that's written is that it's firing squad unless the director of the Department of Corrections says, I have the chemicals and we can do lethal injection. And I think there's 5 days that exist for the director of the Department of Corrections to say, no, we have the drugs, we can do lethal injection now. That is problematic. There's not a choice or an election, and other states have an election for the condemned person to choose from, but Idaho's not allowing that. Additionally, the information that I think is really important to the court is to understand things and advances that have happened in understanding conscious pain and suffering. If Dr. Wolf had been allowed to testify, she would tell you that
Ann Taylor is an advocate in every bone in her body, because even though the court said, hey, we have the affidavit, so that is essentially testimony, we don't need additional testimony, she's continuing to say, if she was allowed to testify, her languaging is so precise, but they are arguing things almost at this point in absentia, which is what, or so far out in the future that it's hard to foresee, because if this is the punishment that is determined by a jury after a conviction, then there are decades of appeals. So where we're sitting now versus the situation that might be decades from now is very different. However, Ann Taylor's goal here, because it does feel like it's not ripe yet to talk about some of these manners of execution. However, she is arguing this as an avenue to try to get that as a punishment taken off the table, and to argue that the jury, he can only be sentenced to life without the possibility of parole. So she's trying to pull all of this off the table and saying, Your Honor, it is in violation of the defendant's rights and the Eighth Amendment to leave this on the table because of the situation. So I will be arguing it now is where we're at. So let's keep going.
She relies on studies from 2010, a working group from 2010, and a book that was published later than that even, and that's post the Bayes decision. And that talks about understanding what a person is conscious and aware of when they face the firing squad. That's
This is going
information
to-
that's important for the
Just a
court.
note, she's going to start to get into this being what people may or may not be aware of, the fear, apprehension. So the topics that we are discussing today, though they are law, so they kind of pull the emotion out of it. It's not easy argument to listen to. I think it's important to listen to, but again, the voters of each jurisdiction get to choose. We do not talk politics on this channel. We talk processes. So understand that the morality of the thing and the legality of the thing are being discussed separately. She is tying them together in some aspects to ask the judge to take it off the table, but these are different considerations. So we are going to just focus on the law today. And I appreciate you guys doing that in the chat. I know it's hard. If discussions of this punishment are not for you, now is probably the time to come back for the timestamps later. So just a fair heads up. But I think I think understanding is important, and understanding what's going on in this case is important. And so we're going to keep covering it. So that's where we're at. So where is the boundaries of this, and what are we going to do with this? So it's odd, I'm sure, to sit there as a defendant or as a victim's family and listen to the arguments about this, because she's arguing the defendant should have a choice. And I'm sure the victim's family are sitting there screaming at their TVs, but where was their choice? So it's a difficult balance. But her job is to focus on this case and trying to do everything she can to get this taken off the table. So that's where we're at.
When considering whether or not to strike the death penalty, because Idaho's means of execution really doesn't exist. Thank you.
Can I ask you, even if your motion were right, and even accepting as true that the current
Two can be precise with language. Even if this were ripe, we know which way this is going.
means of execution are either unavailable or would violate the Eighth Amendment as cruel and unusual. How do you get around Buckwell? You've not provided a alternate means of execution.
Well,
And I know, and I understand from your perspective, it's not something defense counsel wants to do, is to say, no, do it this way. Execute my client this way. But Buckwell provides that if you're going to challenge the means of execution, you have to, as a condition proceeding, provide a available or an alternate, I should say, means of execution.
I would say to your honor that we're not at the place where we would have to make that decision yet.
Speak to your,
Right.
the justiciability of the issue
Because it's
overall.
not right.
I don't think it does. And I think
not
that the
right.
separation and the difference is that we are in a place where we're preparing this case to go to trial. We represent Mr. Kohberger, who sits there, an innocent man right now, but we're preparing this case as a capital case with all of the things that that involves. All
This
of the
is the point.
requirements that are upon counsel that take a lot of time, a lot of work, and a lot of money to do this. And so I think when we're looking at the constitutionality of the execution, I think that's different than if there was a conviction and if there was a death sentence and if the post-conviction proceeding and the appeals were unsuccessful for Mr. Kohberger.
Doesn't that speak to your motion in the sense that you're saying take the death penalty off the table,
Yep.
don't let the state put on that evidence?
It changes this case quite a lot for the defense based on if there will be a penalty phase or not. There is quite a lot of work they need to do, and it shifts the work that they need to do substantially if this is an LWOP case versus if this is a DP case. So it really shifts the difference for them, the amount of work they have to do, the litigation that goes into it. So part of the arguments today of getting this taken off the table would change how they move forward as a defense team. And that is, Matt, that is ripe for discussion. This particular aspect might not be, but there are tons of motions to strike here today that we're going to get to. This one might not be quite ready yet, but it is their option. And for those of you that are like, wait, LWOP, life without the possibility of parole. I'm going to use all the lawyer acronyms today because my brain is tired. It's been a long couple of weeks. So LWOP is life without parole or life without the possibility of parole. DP is death penalty. So I will be defaulting into acronyms today. So she's kind of like, well, I get that maybe it's a little early, but
Because the current methods, in your view, are either unavailable or unconstitutional. But the reality is if he is convicted, we know it's going to be a decade plus before that sentence would be carried out. And who knows what the methods may be then. And, I think that's part of why you're saying you shouldn't have to comply with Buckwell. But it seems to me that that same rationale then applies to why I should even consider this motion. Why wouldn't we wait until that time frame to see what the current methods are? Who knows what technologically is going to be available at that time?
I definitely hear what the court's saying. I would come back to saying that we're not in the place where he's challenging the methods that's about to be employed. We are decades away from that, if that were to even happen. But what I'm saying is, I don't believe that our Constitution allows for us to move forward and make him sit on death row for years and years and years when the way Idaho's doing it right now isn't really working. It's not a realistic option.
though,
I
if it was
think
LWOP,
to
he
have
would
him sit
sit.
on death row and say, Idaho's going to figure out how to kill you at some point in the future in a way that
She's
isn't
arguing
cruel
the
and
waiting
unusual and
is
in violation of your rights.
cruel.
I just don't think that the constitutional protections allow that to happen. I think that
So you're saying the anxiety of not knowing is the constitutional violation?
Yes, she is.
I say that, and I believe that the Troop versus Dulles was cited in the brief, and the comparison there is what I'm saying the Constitution doesn't allow. It is anxiety, it is fear, it is the not knowing.
I mean, to be fair, the Idaho Supreme Court just ruled that anxiety and fear in the Creech case was not sufficient to preclude his execution just this week.
I read that
Oh.
opinion. And I read that, I guess, more particular to the botched execution attempt versus sitting there for decades and not knowing how and if it would happen.
No, but it was anxiety that was the underpinning
Argument?
And I don't mean to disrespect what Mr. Creech felt or went through, but you're talking about realistically from February 29th, if this was leap year, until now, and what you're talking about for Mr. Kohberger and what would happen if he were convicted and if he were sentenced to death would be decades. The court just acknowledged that it's decades to sit. And no disrespect to the anxiety Mr. Creech felt. I think that must have been horrible for him. But to sit for decades and wonder is a lot longer. And so I
But
understand what the Supreme Court.
hasn't the other defendant, if that time is nearing, then the other defendant has necessarily been on death row for decades because it takes that long for appellate rights to run.
said, I did read that too. But I think it's different when you're just starting out here in this circumstance.
Thank you.
All right. As they wrap up that argument and the state's coming back, I did mention, and though it can be awkward in criminal cases to take a break to talk about something completely different, I did mention we had a stream sponsor today, which allows me to continue doing live streams the way that we do them and continue building out Team Baker so we can bring you things like, well, the Quick Bits channel and our lovely interludes when we take court breaks and more. So with all of that, we are going to take just a moment. We are going to thank our sponsor. The rest of the stream today, though I will talk about the Law Nerd Shop, will be brought to you interruption free. So even if you are watching on the replay crew, enjoy. There will be no mid-rolls. And thank you to today's sponsor, which, Law Nerds, you know how I pick. It is stuff that I use. And this is something that I love to use. And for those of you complimenting my hair, thank you. We had to show you how lovely I felt about my skin as I am nearing the back 9 of 40. And I realized my hair being in my face bugs me and then it gets into my in-ears. So it's really just practical at this point. So thank you to today's sponsor. You know, the thing I notice first as we get into fall, it's how dry my skin starts to feel. And that's where today's sponsor, Foreo, comes in, because the UFO 3 has absolutely helped increase my hydration and maximizes a wide variety of masks using a combination of thermotherapy, cryotherapy, full spectrum LED therapy, and T-sonic pulsations. With the Foreo app, you can select the mask that you're going to use, and then it runs the program for that mask to make sure that you are getting all of the best benefits from that mask with the program on the UFO 3. And you can choose the mask you want to target the skincare results that you desire. And I love that whether you choose to use the Foreo UFO 3 with the app or not, it has an easy button on the bottom. So there's literally an easy mode that you can just switch through the different programming modes with the touch of a button. So if you are ready to find out all the goodness of the UFO 3 deep hydration device for yourself, they are rarely on discount, but I've got you covered. Law Nerds, you will get 30% off using our special link down below. And for the first 50 of you to buy, you will get an additional 10% off if you use code 10Emily at checkout. So 30% off if you hit the link. And for the first 50 of you using code 10Emily, you will get an additional 10% off. Don't forget to let me know in the chat which color you choose. Let's get back to today's stream. Thank you, everybody, for understanding how our sponsors keep us supported. For those of you that have bounced over to shop and are going to listen to me in the background, don't worry, I'm going to navigate. Also, sometimes it is just time to treat yourself to a little bit of skincare as we get into the holiday seasons. And I don't have the patience truly for sitting with a face mask on. Also, they scare the crap out of Griffin. So being able to do it with the device and the heating and the cooling, I love it so much. I love it so much. I was like, what is this sorcery? The best. So I use so many of Foreo's products, but we'll talk about more of those soon. Don't worry, we've got another one for you later. So with all of that, let's get back to a less joyous topic than skincare as we talk a long day about striking the death penalty. I saw a number of questions in the chat asking how this changes the way the defense argues the case. It changes the way they prepare the case, and it changes the way they argue the case if there's a penalty phase. The penalty phase has its own experts, its own testimony. It can be a week or two long, depending on the case. So the amount of focus in the case is going to be on both the initial guilt phase and then the penalty phase. So the amount of work they need to do and the amount of experts they need is split between the two phases of trial. If they don't have to worry about a penalty phase, then all of that is something they don't have to focus on. It changes the amount of pretrial litigation, post-trial litigation, and then they can focus solely on not preparing a penalty phase as well, but solely on the guilt phase of trial. So it shifts how they spend their time, resources, energy, money. And so that's part of why we're getting all of these motions to strike now, because it changes the way they go forward for trial. So they need to know what they're facing. It's unlikely that it will get stricken, but they are doing everything they can to argue it. It is their job to do that. So with all of that, let us continue on, as we are going to get a full day of arguing this. And the state's going to be like, it's too soon.
Aye.
Your Honor, I'll try and keep this brief. I don't want to repeat much what's in my brief, and I think a lot has already been discussed today, but I want to start by pointing out, one of the things that Ms. Taylor just said was, looking forward, we don't have the answers to that yet. Well, that's the whole point.
Because it's too
just isn't
early.
right. We don't know what's going to be available decades from now, and it probably will be decades, plural. If you look at, Idaho's track record, Mr. Creech, Mr. Pizzuto, they were convicted back in the 80s.
Take as true, for the purposes of my question, that the state doesn't have a method. Should defendants be tried for and potentially sentenced to death when the state has no method of execution currently?
Yes, Your Honor, I don't see a problem with that, because deciding the method of execution is not deciding the sentence. The sentence is death. The method of execution is just how that's brought about. And so even the
Appellate
United
courts will
States Supreme
decide it
Court has
later.
recognized that someone who was convicted and sentenced to death, in that case, I believe it was hanging. And then after he was sentenced to death, the state passed a law, made it electrocution. And the U.S. Supreme Court said there's no ex post facto problem with that, because you're not changing the penalty.
You're changing the
Penalty is death.
method.
And so even if you assume that Idaho cannot do lethal injection, and even if you assume that the firing squad is unconstitutional, that's not to say that decades from now, there is not going to be a method by which the state could put him to death. And then, of course, I was accepting the hypothetical as proposed, but we would strongly push back on this idea that Idaho doesn't have a method of execution. There was a scheduled execution to take place on November 13th, just days from now, that was only stopped because the federal district court entered a stay so that it had time to consider some additional claims. But in that case, Director T-Walt put in an affidavit that said, we have the chemicals, we can do this. We've modified the procedure to address the individualized problem that came up with Mr. Creech before, and so we can execute Mr. Creech. So there really is just no evidence whatsoever to suggest that Idaho can't do this, and certainly not that it can't do this decades from now.
Yes.
And again, that gets back to the ripeness issue. Is it may be lethal injection, it may not, it may be some other method, but we just don't know enough now, frankly, to spend the time and the effort debating what we don't know in the future. That's the entire reason the ripeness doctrine exists.
Right.
I also want to speak just briefly on the Bucklew point that the court brought up. What I'm hearing from the defense is they just have this kind of like vague Eighth Amendment assertion of maybe it's kind of the anxiety, but kind of not knowing how you're going to be executed. Well, that's not how the law works. There's an established framework of how you can make an Eighth Amendment method of execution claim. And Bucklew, the court specifically said, I'm quoting here, identifying an available alternative is a requirement of all, and all is emphasized in the decision, all Eighth Amendment methods of execution claims. You can't get around that by just saying, well, but I'm making a slightly different kind of claim. It's not a method of execution claim, it's a means of execution claim. That just doesn't work. That's not how the law operates. And so they haven't even suggested, even today, an argument what a proper alternative would be, which also gets back to the ripeness issue, which is we don't know decades from now what an alternative might be. Maybe they'll have a better argument decades from now on the method of execution, because maybe there will be a better method. And that gets to the final point I want to bring up, which is the remedy here. They're asking that the death penalty be struck because these methods are unconstitutional, but that's not how it works. If you show that one method is unconstitutional, part of the reason you have to present a viable, readily implemented alternative is so that the state can then use that method for the execution. You don't get to, at the beginning, short circuit the whole thing and say death is off the table because the current method is unconstitutional. As I said before, the method could change. And so if they came in and they had evidence and they could show that there was another method that's not lethal injection, that's not firing squad, that severely or significantly reduces the pain, and it's readily implemented, the answer isn't to strike it, the death penalty completely. It's to say, okay, you can move forward with the trial. We can see if he's sentenced to death, but you can't use those two methods to do it. If the state wants to pass a law and do this other method that he's proposed, then you can do it that way. So for all those reasons, Your Honor, unless there's any further questions, we'd ask that the court deny the motion.
Thank you. Any rebuttal?
And Chad, I will just remind you, though they are talking about a potential sentence if there is a conviction down the road when this goes to trial late next year, it's because it changes things for the defense. They want to try to have this taken off the table. This is the time to have these conversations. We have not followed any cases with the death penalty on the table from the beginning of there being an arrest through trial, but this is the appropriate time to have these. I've seen a lot of people asking, is Ann Taylor just trying to delay things? This is not a delay tactic. This is Ann Taylor doing her job. I don't think this particular question is ripe, but I understand why Ann Taylor is bringing all of the motions to strike together. This is the appropriate time to have these conversations. It doesn't change the presumption of innocence in the case, but these conversations have to happen because of the significance of preparing for a trial as a potential DP case with a potential penalty phase. It's much different, and it takes a lot more resources. So that's why we are having that conversation now. It's an appropriate and timely conversation to have, though I think this argument's not ripe. And it doesn't change the presumption of innocence, though it has to be weird for everyone involved in this case and watching this case who doesn't normally engage with court process in this way to watch these conversations happen in a linear and neutral way because it feels so weighty. This judge, I think, got dragged back from the appellate bench to sit in trial here. Can we talk about the fact that he is just like, but what about this? And what about this? And what about that? Like, it is just a mood. But for anyone standing accused of anything, you want an attorney who is going to fight every single motion. Ann Taylor is doing her job. For all of those that cheered for defense attorney Bryan Steele, I don't see how you can't cheer for Ann Taylor in the same way of, I might not agree with the argument, but they are doing their job. You want an attorney who does their job well. These are the same arguments Alan Jackson would be making were he in Ann Taylor's shoes. And if you go and look, I know a lot of you in the chat like Alan Jackson and the way he tries his cases. If you go and watch some of the defenses of other clients that you might not like, you will look at some of Alan Jackson's argument, I imagine, and go, oh my God, I can't believe you said that, because they're doing their job. So I appreciate some of you are like, it's stalling. I don't think that she is. If I do think that she is, I'll tell you. But she is doing her job the same way a Bryan Steele is, the same way an Alan Jackson is, where she is a ride or die for her client. So that's what everyone deserves and should have. Every accused, no matter what they have or haven't done, should have someone in their corner. That is the system that we have. And good defense attorneys make a tremendous difference. as do good prosecutors. This prosecutor has been very easy to follow. No Adam Lally here, and I appreciate it. So thank you all. We want to see good lawyering on this channel. I am so big fan of good lawyering. I am a big fan of good lawyering. I don't want to watch a football game that's like 75-0, and I don't want to watch a case where one lawyer can't figure out what's going on and the other lawyer is trying to hold back from trouncing them. I want to watch good lawyering in court. I want to see good judging. I want to see people be excellent at their job. So that's what we're here for today. So thank you, chat. I know it is a difficult topic, but I appreciate it. I will stop now. Let's keep going. We don't really need a rebuttal on this. Let's keep going.
The distinction is not us being on death row with a death warrant that we're talking about. That's a different kind of conversation. We're well before looking at the overall picture and saying the Constitution protects somebody from sitting in prison when there's not a real means to execute.
Do you
I
have any
understand.
case that says that?
I'm making an analogy with the troop versus duels and the denaturalization with the dehumanization that happens if somebody sits on death row when there's not a realistic way to execute. I understand that lethal injection has not been overruled. I understand that. But when we're talking about the recent history of what's happened in Idaho, there are problems, and there are real problems. We talked about Pizzuto, we talked about Creech, we talked about 2 pieces of legislation to try
Yeah, the
to
court's
make
not
this
going to hear
work,
much more of
and
that.
it just doesn't work. So we're in a position where I'm not with a client that has a death warrant, and we're talking about whatever they'll probably talk about with Creech, with how they're going to do injection. We're
That's
not talking
too
about the
early.
marksman involved in a firing squad. We're talking about way back here when we're sitting with constitutional protections, and Idaho's got all these
I mean, those
problems
don't go away,
with
though.
executing somebody. And how is that right, fair, any protection under the Constitution for somebody to have to sit there and just wait for Idaho to figure it out? That's the difference in our argument. That's it. Thank you.
Thank you.
She knows that it is an outside argument. She is going to make them. That is her job. The judge is like, we're moving on.
All right, court will take that issue under advisement and issue a written opinion with respect to its ruling. Next, I want to take up the objection to Professor Kohberger's testimony.
This is going to be a similar argument because it's a similar thing. So we're just going to do that again, different expert. Petty AF, no, but I'm not a defense attorney, so it's different for
Your Honor,
prosecutors.
as the state pointed out in its written objection, Professor Cover's testimony is
Is it
largely,
Cover or Kohberger?
I believe, I'll defer to defense counsel. Is it? It's Cover.
Cover, thank you.
Thank you, counsel. Professor Cover's testimony in this case would largely
How do we pronounce it? Not sure. Yep. This is a second expert that they are talking about.
center around a legal analysis that she conducted over several other murder cases throughout Idaho. Now, the first reason that this isn't appropriate is because legal conclusions are just not the appropriate subject of expert testimony. The state cited to Ybarra in its objection, and in Ybarra, the Idaho Supreme Court held that legal conclusions by an expert were not proper for consideration before the court. Now, that expert was allowed to testify as to factual conclusions, but the court struck legal conclusions from that expert's declaration. Additionally, as the state also pointed out in its written objection, the Idaho Supreme Court straight up rejected a similar attempt to do an analysis over first-degree murder cases in an attempt to argue that Idaho's statutory scheme doesn't accomplish narrowing. And so I think the court can look to the Hairston case where it was an almost identical argument, and the court found that it simply wasn't relevant, and also preclude Professor Cover from testifying on that basis as well. When the state received the PowerPoint that Professor Cover would be utilizing, many of these slides are simply simply excerpts from statutes. This PowerPoint itself is titled An Empirical and Constitutional Analysis, and that's largely what her testimony would be, which is a constitutional analysis leading to her conclusion that Idaho's statutory scheme just doesn't accomplish narrowing. This is a legal argument, and the state would ask the court to preclude her from testifying on that basis.
I
Thank you, Your
love the
Honor.
jacket, the black shirt, the necklace, the glasses. I love everything about that look. There's a vibe.
Good morning, Your Honor. The first argument that I'd like to address.
I would like to address, I am incredibly biased against white shirts because I always spill coffee on them. So the black shirt, light jacket, a whole vibe for me. When you go dark jacket, white shirt, I wish I could, but I cannot. But I'm vibing with the lipstick.
Relates to Hidalgo. And in the Hidalgo case, the state of Arizona had actually conceded that there were statutory problems. And when the Supreme Court took that into consideration, the reason that they did not issue a cert was that they wanted a robust discussion about gathered data, analysis, and have that come under the scrutiny of cross-examination. And so
Interesting.
that's my first point to you today is that the United States Supreme Court wants what we're wanting to accomplish here today with Professor Cover. They want that discussion to occur so that the data is and studies
judge's
are
face.
scrutinized and discussed, and a trial court like you has the ability to make a full assessment.
How does the
Reading
Idaho
a
Supreme Court
paper
feel?
doesn't allow you to do that the way that the expert who did the study can explain it. The other point that I want to make is that as it relates to the Hairston case, I pulled the underlying briefing in that. So the underlying briefing in Hairston was a direct appeal and a post-conviction.
She's like, Your Honor, we did a deep dive. I didn't just pull the opinion. I pulled all the briefing under the opinion. We went all the way in, Your Honor, all the way in. And the judge is like, okay.
Appeal, and they were consolidated. And the study that Dr. Jensen did was nowhere even close to what the study that Dr. Cover did.
But the court's thrust was that the legal analysis is not whether the statutory aggregators cumulatively narrow the class of first-degree murders eligible for the death penalty. That's not a relevant legal analysis. The legal analysis is whether an individual aggravator does so, and that it excludes rationally first-degree from among first-degree murders within that particular aggravator.
So they are arguing, just as a asterisk, they are arguing over whether Professor Cover can testify regarding whether or not the statute specifically narrows down the cases. They're going to argue more about that later. So the argument about who can testify today is coming first, because then there's argument that that the testimony would go to next. So it's a little backwards. So if you're feeling like I'm a little confused about what we're doing, I understand they are preempting the argument that's going to come later, which is hard when it is back and forth, but it's, does this person get to testify as we start to argue next? So I promise it will all, I can't promise that, we haven't watched it yet, but I am optimistic it will all come back around and make more sense as we get into the heart of those arguments down the road.
And as I understand Hairston, it's just not a relevant issue. It's not a legally, it's not an issue that upon which the question turns.
Well, Hairston was decided
That I'm a trial court and not the Supreme Court.
and I'm
Yeah.
sorry I interrupted you.
No, that's
Hairston
okay.
was decided in 1999, which was a long time before Hidalgo was decided. And so the United States Supreme Court has absolutely made the issue ripe and said, we want to hear what the specific data is, and we extend the invitation for that to be done. The study in Hairston was framed as, did Idaho's method of compelling financially burdened counties to bear the cost of litigation in capital cases result in arbitrary and
That was
capricious
the claim of
application?
geographic discrimination.
Pardon?
Wasn't that the claim of geographic discrimination?
It
different
was, it
than
was
what they're
based
arguing.
on money and whether or not an urban
That's
versus a
different from
non-urban.
the issue of what the relevant legal framework is with respect to whether or not the aggravators are overbroad or over-inclusive.
I
as a
agree.
whole.
I
is
agree,
a
but
different
before we
argument.
get to even there, Judge, which would come under our motions to strike, the heinous, atrocious, and cruel, and utter disregard,
Later motions.
and propensity, the other motions that we have before you, we first have to focus on the eligibility and looking at eligibility of the death penalty in the state of Idaho, which is a legislative function that looks at the statute and then the aggravators as a method of narrowing, and whether or not that results in arbitrary and capricious application for purposes of the Eighth Amendment. And that's what Professor Cover's study addresses.
Correct. It doesn't address whether an individual aggravator is itself overly inclusive. It doesn't do it based on, in fact, she generalizes the aggravators as quote unquote the fuzzy ones, I think is what she called it. And then the, I can't remember what the name.
Clear.
The clear ones
Great.
were.
The
Right,
fuzzy
but-
ones and the clear ones for the
her
special
study is a
circs?
good foundation.
Okay.
When you're get into the next level of looking at those aggravators and the definition of fuzzy and what that really means in terms of the analysis to strike those individually. So we have to begin with looking at whether or not we should even be getting there in the selection process.
Right. But I guess my concern is that the Supreme Court, the Idaho Supreme Court has said that that's not the issue. When we look at whether the aggravators are unconstitutional as being not sufficiently narrowing of the class of persons or crimes available for the death penalty, the Supreme Court specifically rejected a approach that is based on the cumulative effect of the aggravators together. It said you have to look at each individual aggravator and ask with respect to that aggravator, does it exclude sufficiently? Am I wrong about that?
I don't disagree with what your statement.
Why is this judge such a vibe? Also, his face is me when I'm looking at my kids being like, am I wrong? They are arguing still whether or not this expert will testify over aggravators that take the case from being this is an LWOP case to this is a death penalty case, and whether those aggravators are not overly broad, which is arguments they're going to get to later. They are just arguing whether that person can testify. But part of arguing whether that person can testify is that person testifying to the issue that is not outside the purview of what the Supreme Court has said. So the judge is like, look, the Supreme Court has said that that's not the point. So if your person's coming in to testify to something that the Supreme Court said is not the point, then we don't need them to testify because that's not the point. So this is why we're still arguing over whether or not this person can testify.
As I'm saying that we've got to start before that with the analysis of who is eligible
Right, but that's
to
the
be
point.
charged with the death penalty.
That's-
But it begins, Judge, with the definition of first degree murder. You start with the definition, which is very broad, of first degree murder,
which is why the aggravators are required.
right? And then you look at what happens within those aggravators. And we are arguing about the individual nature of those aggravators in other motions. So, these are different arguments.
But you, in those other motions, didn't rely upon Dr. Kohberger's article.
No, that's true, but it still comes to the issue. You still have to look at the issue of eligibility before you get there.
But the aggravator is the eligibility.
So for those of you asking in the
Part
chat,
of the analysis.
for those of you asking in the chat about aggravators, in some jurisdictions, you'll hear them called special circumstances. They are other things outside of like first degree murder. And then they are the other things that take it from being just a first degree murder into being an eligible case. So sometimes you hear special circumstances, sometimes you hear aggravators. In this case, the state has filed a number of aggravators. They're going to argue over that later. They are very narrowly and specifically defined, which is why the court isn't talking about it much, because those will come up. Those include the especially heinous, atrocious, the multiple victim, the utter disregard, the felony murder, and the future dangerousness. Though I saw in the chat that they said the state had withdrawn the felony murder, which is possible, and then they won't argue over that. So they are specific, fact-specific things that are defined as if a case has, for example, multiple victims. In Idaho, that's one of the things that can change a case from being LWOP to being death penalty. It's a conversation that's being had a lot right now in California over the Menendez brother case, because to resentence them, you would need to strike the special circumstances that they found in that case. You could synonymously say aggravator the way they use it here. So that's what they are talking about. Those are narrowly defined by law, and they're going to ask to strike those as well. So that's coming later. We're going to get to those too.
I mean, everyone agrees the statute itself as to first degree murders that are eligible is without more unconstitutionally vague. That's why the court has U.S. Supreme Court then later approved statutory aggravators, including with judicial gloss, right? And so then the question, the court.
Somebody make a note. I'm naming something judicial gloss. I don't know what it is, but we're going to find it. What he's talking about is that the imposition has to be fair. So we're starting to get into constitutional arguments that there cannot just be a capricious assigning of this person gets that punishment, this person gets that punishment. There has to be equal protection. And they're saying that first degree murder itself is too broad of a category. So how do we know who's eligible for this or that? And so that's the argument now to narrow it down.
Has said, the Supreme Court of Idaho has said, and the Supreme Court of Arizona has said is, and other courts, not whether, when you look at all the aggravators together, cumulatively, do those sufficiently narrow? The question is, when you look at an individual aggravator, does it exclude first degree murders from it? Does it narrow first degree murders? And you look at those each individually and not cumulatively. My understanding is that Professor Kohberger's analysis is that taken as a whole, these don't accomplish that. Is that accurate?
Uh-huh.
I would yield to her to testify to that, Judge.
Well, I've read our law review article, and that's what she says.
That's the purpose of having her testify. I think that it comes in
not gonna happen.
segments, and you have to begin with the definition, then you have to get to the aggravators, and then you have to look at what is the quantity of cases in Idaho that fall within both of those, pair it against what the result is for it being arbitrary and capricious. And when you're talking about our court, you know, the Hidalgo case is from the United States Supreme Court, post-states what our court said in Hairston.
So did it change Hairston?
The other concern I have, I'll save that. I'm just now thinking about whether I need Dr. Kohberger. Why can't I rely on her law review article as a proper?
They want her to testify.
Well, Judge, you are the trier of fact here, and it's important that you listen to, I believe, to make a reasoned decision, hear testimony, and hear that testimony be confronted and cross-examined. And that's what the United States Supreme Court said. I mean, if the state were to stand up here right now and say, hey, we concede, the statute's overbroad, the aggravators 11, everybody fits.
Worth a try.
What the United States Supreme Court has said is, we appreciate that concession, Arizona. It may genuinely exist, but we are a justice system where we want to hear that data talked about. We want to hear those issues confronted. We want to hear that debated. And so as a trial
I
judge
don't
in
think the
this
court wants
case,
to hear it debated
this is
today.
the appropriate time for you to hear that so that you can make a reasoned decision, not just based on her paper, but based on her explanation. One of the arguments that the state has made is that, you know, we don't know what she's gathered, what her methods are. Well, she'll be able to testify to that, to explain that to the court, what her approach was. And it was different than what happened in Hairston years ago. And so for that reason, this court should hear that so that you can make a reasoned decision.
I don't think that's what the court's going to do.
Your Honor, I'd like to address the foundation issue because even if this court were to use the denial of cert in the Hidalgo case as a basis to delve into this issue at this time, Professor Cover's data does not provide adequate foundation to be reliable enough for the court to do that. And what I mean by that is that if you look at the Excel spreadsheet that was provided as an exhibit, I would direct the court's attention to just 4 examples. Line 22, the Nuxall case, death notice was not filed in that case. And Professor Cover did a review of the documents that were available to her and labeled that case as clear hack. Now, the significance to her designation
HAC.
as clear hack is that elsewhere, when she designates cases as hack or utter disregard or propensity, which she describes as fuzzy aggravators, she doesn't designate everyone as a clear aggravator. She only designates this one in particular and potentially others as clear, which then calls into question, well, are the others not clear? And potentially did the prosecutors who were determining whether or not to file death perhaps have more information available to them that enabled them to determine that, in fact, that those aggravators did not apply. The next I would direct the court's attention to would be the Huntsman case, line 33 in that spreadsheet. That case was labeled utter disregard / propensity ? Again, if Professor Cover can't determine for sure whether or not these labels apply and has to place a question mark in there, and she's relying on the court record, not necessarily the entire body of evidence that the state would have had before it when it determined whether or not to file that notice. Again, she isn't even sure herself, at least according to the spreadsheet, if those designations apply. Carlos Alonso Sandoval, line 44, her notes indicate possible hack. No death notice was filed, and according to that spreadsheet, it would have been included in her study. Yet she writes possible hack. And there was no clear aggravator in that case, I believe, Your Honor, which means that, again, we're including this case based on the fact that she's designating that it might apply, possible hack. Finally, I would point the court's attention to line 52, Angela Cervantes. The state did not file a notice of death in that case. Now, there was a clear aggravator, according to her, for kidnapping. But again, when she lists whether or not a fuzzy aggravator applies, she writes utter disregard with a question mark. Again,
there's no notice.
Dr. Cover is relying, according to her article, on documents she was able to obtain from transcripts from the state appellate public defender's office. She did not indicate in her article that she had, I don't think she even argues that she had the same body of evidence that the prosecutor would have had in each of those cases, making those determinations. So what's essentially happening, and this kind of brings us full circle to the legal analysis issue with all of this, is that she's reviewing court records, making a legal determination that's different than the prosecutor who made that determination whether or not to file a notice of death, intent to seek the death penalty. This is not a reliable body of evidence upon which the court could even make that determination, if the court even wants to consider it as evidence, which in the state's position, it's really just a legal analysis where Professor
Which the court
Cover
can do.
is just reaching a different legal conclusion based on court records and providing a statutory analysis. And so the state would just argue that her article is a sufficient proffer. We would ask the court to grant the state's motion and to disallow her from testifying today. Thank you, Your Honor.
Thank you.
It's like, Your Honor, you have what you need. So let's see
Oh,
what.
actually, that was the rebuttal, wasn't it?
Yes.
If you'd let me talk,
I will indulge you for my skip.
Me, this defense attorney is me. But if you'll just give me a second, I've got something to say. The state is objecting to this testimony today. They're like, the court, you know what she's going to say. You have the law review article. The argument is whether or not this witness will be allowed to testify to support the defense motion to strike the aggravators in this case, therefore making this case not a DP case. So that is whether or not this witness will testify to support the other defense motions to strike. The state's saying this is just to legal conclusion. The court can make a legal conclusion. You're the court. We've already seen a proffer of what this witness will say. We don't need to have live testimony today.
Schedule is already shot to hell, but we'll indulge you.
Judge, we will be able to get through in one day. I think that
All
what the
day?
the argument that the state just made beats my point, which is they're drawing conclusions off of the raw data without talking to the expert. You know, when an expert provides their spreadsheets and has notes without asking Professor Cover what a question mark means, what the exact records were, why she used those records, why the conclusions she drew were drawn. You have, first of all, you don't have the exhibit because it has not been admitted. It's been provided to them because they were raising issues about wanting to see the data.
Right.
Or if she's allowed to testify, she can
Right.
talk about that.
This is the data that she used with respect to her law review article.
Right.
Correct. To draw her conclusions and do her study. And so,
And that law review article was as of 2019?
yes, yeah, yes. And so I think that the state just actually made the exact point that I'm trying to make to you. Thank you.
So you, since I have you, you
What-
brought up Hidalgo.
What point was that? I missed it.
And you talked about the Supreme Court doing this.
Trying to
My
remember
reading of
if I told my
Hidalgo is
Snorlax.
that cert was denied. A minority of justices issued their own statement in which they thought it would be important to gather additional information. The court itself did not.
That
Am
was
I
my phone, not
correct
yours.
about that?
Well, you're correct that cert was denied, but Hidalgo has been viewed across the United States as an invitation. It's not just Idaho that's done this, done a study. You know, other states have done the same at the invitation of the Supreme Court.
An
because
invitation of 4 of 9 justices of the Supreme Court.
Correct. It's still an invitation, and it's been accepted as an invitation.
Okay.
So
Oh, my kid needs
I
me to
don't
send
find
him
that
something.
the proffered testimony of Dr. Cover will be relevant or helpful to the court to
Yeah, I'm not
decide
surprised
this
by that.
issue. I think that I can rely upon her law review article and the data that I understand that has been provided today as a proffer of what that testimony would be. Of course, the constitutionality of Idaho's capital sentencing scheme is a question of law. Whether to allow expert testimony is committed to this court's discretion, specifically the well-known 4-part My Fun Life standard.
Is my fun life an Idaho case? Because I have so many questions. Or is the court being snarky? I can't tell if that's a case site or if the court's being snarky that this is a 4-part test because my life is so fun. I don't know. I hope we find out. Let's continue. I keep saying let's continue. And
Opinions
There
as
we go.
to the law are generally not admissible by experts. The court is the determiner of questions of law and not what somebody else's opinion of what the law is.
This was the
opinions of
argument
what the
Sarah
law
Boone
is
too,
are
with one of the experts.
received by the court through counsel, not through expert witnesses. And so generally, I would not have permitted expert conclusions about the law. And therefore, her opinions are neither relevant nor helpful, and therefore not admissible.
So the state's motion
Importantly,
is being granted. The state said that there was not sufficient foundation to allow the expert to testify based on most of what the court is saying now. So the court is now saying, look, yes, there's no foundation because the expert's opinion would be a legal conclusion, and that's what I'm here for. Thank you guys for letting me know what the case
Idaho
was.
has opted to satisfy the constitutional narrowing requirements from the U.S. Supreme Court through the adoption of statutory aggravators rather than through narrow definitions of capital offenses. The relevant,
Thanks.
as I understand
Thanks,
from reading
research
her
attorneys
article,
in the chat.
Professor Kohberger's analysis is offered to support the argument that collectively Idaho's statutory aggravators do not sufficiently narrow those first-degree murders, which would qualify for the death penalty. But that is not the question that the court must answer. The relevant question is whether a particular individual aggravator provides a principled basis for distinguishing between those who deserve the death penalty and those who do not. The Hairston case, I believe, makes that clear. The court is bound by binding precedent of the Idaho Supreme Court on this issue. Therefore, I don't feel the need to take Dr. Kohberger's testimony. I think the issue is sufficiently preserved through her law review article and the data that was provided. Now, if I look at this when I write this issue up, I certainly can invite counsel and Dr. Kohberger back at a later date to provide that information or to help clarify some of that information. So from that perspective, I don't think Dr. Kohberger's testimony is needed this morning. Now, I'm not going to preclude the argument on the merits using Dr. Kohberger's analysis, because certainly counsel has the right to make a record of their argument on that as well. And so I will hear argument on the merits of the motion to strike the aggravators writ whole. This is not the argument on the individual aggravators, but on the collective aggravators.
Sorry, I'm going to try to mute my phone. My kiddo has passed through of my do not disturb. So let me mute that again. That's my phone, not yours. Sorry, y'all. All right. As the court said, we don't need testimony today. We're moving on.
We are asking the court to strike the death penalty because in Idaho,
We're now
there is
moving
no
into the
narrowing
defense
of
motions.
eligibility, which results in arbitrary imposition of a death sentence. We are also asking the court to strike the death penalty as a violation of the Equal Protection Clause. I will argue narrowing first. When it comes to the determination of eligibility, it begins with the definition of first-degree murder. And when the definition of first-degree murder is looked at, then the next thing that happens is looking at statutory aggravators. And the reason that those two things exist in Idaho and those steps in analysis exist in the United States is because of the Furman case. It's important to distinguish between eligibility to be charged and selection, which is at a post-conviction phase of a case. And so our argument and our focus for this issue is on the eligibility phase. What
Your argument
defendants-
doesn't consider the weighing of mitigators against the aggravators is what you're saying, and the appellate review available. You're simply focusing on whether collectively the statutory aggravators narrow the class.
let me answer the mitigation question first. Mitigation is in the selection
Right.
phase.
That's what I'm
So
saying.
I'm not arguing about that. I'm going to step and grab my water.
Sure.
The court is incredibly well versed on the
I want to be
motions
clear. about the
and is narrowing down the conversation and keeps narrowing down the conversation so that these decisions can be made. And again, the court's job is to interpret the law as it is today and move through this case with the law as it is today. If the law changes, things change. But these are now into the defense's motions to strike, and they have numerous motions to strike. We're getting into just a few of them. This is going to be, I think there are 4 or 5. I would need to go and actually count them, but there are numerous motions to strike for different reasons. So we're getting into some of the reasons to strike. There will be others soon.
argument and eligibility that I'm talking about the definition of first degree murder and the aggravator statute, because our definition is so broad that there is no narrowing there. And so that is an important first step that the prosecutor in their discretion, they're looking at, and there's essentially no guidance with the first degree definition. And so you do get to the narrowing factors, which is the duty of the legislature that cannot be abrogated to any other branch to fix when there is no proper narrowing. Professor Cover concluded that when you analyze those things with the 195 cases that she reviewed and collected data on against the number of death verdicts, which is so low, that you end up with a statistic that is worse than the statistic that the Supreme Court struck down in Furman.
Well,
And
so the Furman's an interesting decision, right? Because while I recognize
Is
two
it?
of the justices talked about those specific statistics, I don't know that those specific statistics are in fact a binding opinion of the court. There's much more in Furman apart from the statistics that two justices relied on.
And I don't disagree with that, but it's certainly guidance for the court. You know, when you're not hearing testimony from the expert to explain everything that was taken into
See, Your Honor, we
consideration
want our
in the conclusions that she drew, then what I'm going to do is take it at the high level that Furman is the guidance of those statistics. Her statistics show that Idaho's were vastly worse. And so it's certainly something that the court needs to take into consideration in terms of whether or not there is the ability to narrow in the state of Idaho. The conclusion from the expert who did the study here is that there is no narrowing.
And my question was more a legal one, which is the analysis by Dr. Kohberger in her extensive law review article takes as its starting point that you have to have a statistic below that identified by the two justices in Furman.
Your Honor, I guess I disagree that that's where she draws a hard line there. I think that it's guidance.
Okay.
And there were other states that she looked at that she could certainly, if she testified, explain what was going on in all of the things that were going on in her analysis. But I don't know that my interpretation is that there's this hard and fast line, but certainly we have a line that the United States Supreme Court looked at, and Idaho's is worse. So the problem when you have no narrowing is that instead of it being a situation where the worst of the worst are being charged with the death penalty, everyone falls within that category. And
I
that
don't
cannot
know
be
if that's
remedied
true.
by anyone else other than the legislature, because that is their duty. And if there's no narrowing, then and it's arbitrary, then that's a basis for this court to strike the death penalty. There were, when Dr. Cover did her study, she looked at other states that did a better job of narrowing in statutory aggravating factors. And I want to give the court an example of what that looks like. In the state of Oregon, which actually is on pause with its death penalty right now, a narrowed statute there is the murder of two or more people or terrorism while in custody and after a previous homicide conviction, premeditation and against a child under 14 years of age, or premeditation and against a police officer or an other officer. So that's an example of how a legislature can certainly make an
Interesting.
attempt at getting factors much more narrowed and tailored. Now, Oregon's hasn't been, as I understand it, has not been taken up on appeal, so it hasn't been analyzed at this level, and the death penalty is on pause there. But it is an example of a statute that can be narrowed. The other thing that I wanted to point out is that the state of California versus Tulipa, and I hope I'm saying that name right, has a statute for aggravators that in and of itself carries a whole bunch of mitigating factors for the state to actually take into consideration. So the state doesn't wait until it's very clear that the state is looking at what only happens in Idaho at the selection phase and not the eligibility phase. The other
What were
point
we
that I
talking about,
want to
California? What
make
happened?
about our motion on this is the issue of geography. And I want to point out that we are arguing geography in the context of equal protection, which is a unique argument that has been made in Idaho and has not been addressed on appeal when it was being raised in Harriston over financial resources. And the point was geography. It was in the context of arbitrary and capricious and not in the context of equal
But as I
protection.
understand your analysis is that the geographic, there's a predilection for capital cases to come from geographic centers of large populations, correct?
Correct.
Client's case does not stem from one of those.
That's true,
Right.
Judge, but this is not, we're not talking about the facts of our client's case right now. We are talking about Idaho's
Your claim
statutory
is
scheme.
The facts matter because it's aggravators.
on the whole, your claim is that it violates equal protection.
Correct. And
I imagine
and not only
based on what this defense attorney said, and I'm sure attorneys in Idaho are like, yeah, obviously, Emily, thank you for catching up. But based on what this defense attorney said, I suspect, like we have seen earlier in this case, that the arguments that are coming up that the defense team is bringing regarding the death penalty in this case are coming up in every single case across the state, trying to see which one is going to get to the appellate court so this will get reviewed. If all the defense attorneys in the state are making same and similar arguments across the state, one of them will eventually get reviewed. So she said these arguments are being made across the state. So we talked about this, maybe it was yesterday, where you will see the change in culture of what attorneys argue first as it pushes through change in law second. So if everyone is arguing this and they're saying it hasn't been taken up yet, there is a push-pull over how the death penalty in Idaho will move forward. And that's why we're seeing some of these arguments saying, hey, under equal protection, we're arguing this, and other states have addressed it in this way, which is why you're hearing other states being brought up, and it could be addressed here in this way. And I imagine what the court is going to say, yes, but in this state at this time, the law is this, but it preserves those arguments to go forward later. So that's where we are at. And again, if these arguments are being made in other cases across the state, they are going to be very similar and on the same points. And that's why you're going to hear all of them.
An Idaho level, but
Which is
also
not inappropriate
on
in
a
any way.
national level, when you take into
Why
consideration
we're hearing
how
about
many
other
states
states.
have stopped using the death penalty or paused using the death penalty. So it's geographical at a state level, and it's geographical at a national level.
Your Honor, if these crimes are committed in Oregon, then this wouldn't be the penalty. So under equal protection, someone in Idaho shouldn't be punished differently than someone in Oregon for the same crime. And the judge is going to say, but this is Idaho, and these are the laws here. Because anyway, I'll let the judge make his record on equal protection.
Interesting. I think the last 3 or 4 death penalty cases have come from outside those geographic centers in Idaho.
In terms of the southeastern Idaho,
2 in southeast Idaho, and I recognize one was death penalty was taken off the table for reasons outside the control. Well, I suppose not ultimately outside the control of the state, but because of the state's failure in discovery. This
That's
case,
Daybell.
And then I believe there was another one up in the 2nd district
That he's
relatively
talking about.
recently that then was resolved.
and I can't dispute
Well,
that.
not David,
That
the
still
yeah.
does not eliminate the fact
companion
that in
Vallow. Thank
Hairston,
you.
the doctor
Thank you, chat. The companion, I was like, Vallow Daybell in my brain has started to go together in the Vallow part of that case. It was taken off the table for discovery violations. So that's what the court is talking about.
Dr. Jensen concluded that there was a geographical issue. And in Dr. Cover's study, she made observations about geography as well.
But even she confessed she couldn't make any conclusions based on that.
And that was why I used the word observation. And had she testified, she would have explained her observations
Had she testified,
regarding
Your Honor,
that.
but you
But
didn't let her.
it is instructive to see that a study that was conducted in 1995 in Hairston has the same results in 2019, even if it's just an observation about geography. One of the things that the Supreme Court mentioned in its decision in Hairston is that they really wanted more information about the data that had been gathered and the reasons that there was a determination by Dr. Jensen regarding that and more analysis. But nonetheless, that was Dr. Jensen's conclusion, and they are Professor Cover's observations. For those reasons,
I was wondering if
we are asking that
something had
you
frozen right back. I
find,
was like,
based on Professor Cover's study, taking it at face value with its conclusions and providing you with the data that we will look at and redact
If I
names.
go there, in other words, if I accept that there's an actual valid analysis to be done here, would you agree that I need to look at the cases since 2019 as well?
I think, Judge, that the point of bringing in an expert today to talk about a study is that that's her expertise in gathering the information and putting it into a compilation. For you to engage in that on an individual basis.
Well, I can't take her opinion because it's a legal conclusion. Looking at her data, which is 5 years old now, it seems to me that if I were to engage in that, I would have to look at the data as of today and not as of 2019.
that's fair.
Yeah, I guess I'm not willing to
Say that.
concede that. And if it was something that, needed to be undertaken, I'd like to have the opportunity to have Professor Cover testify about
She's
her
got no opinion
timeframe.
about that.
Pardon?
She's got no opinion ultimately about that. She has some data that she collected that she thought was interesting and might require some additional study. I guess the point is, if I were
Oh
to
boy.
engage in that, it seems to me relevant, at least as to the state claim claim that the state equal protection, not the state equal protection clause, but the equal protection as applied within Idaho geographically, would need to look at that as of the time frame now.
Well, it could certainly be instructive, Judge, but, if you're taking the data from Hairston, which was 1978 to 1995, and Professor's Covers from 2002 to 2019,
He's like, right.
the data, if it was analyzed, I'm quite certain would support both of their premises. I haven't analyzed it.
He's like, but in the year of our Lord 2024, ma'am.
We could have that study done, but I think that there's enough guidance with all of those years of data to be able to draw the conclusion that it's arbitrary and capricious today, because the statutory language is still, the definition is still the definition. The statutory aggravators are still the statutory aggravators.
I have a case that indicates that an equal protection analysis can be applied on its face as opposed to as applied, because my understanding is an equal protection clause has to be analyzed as applied.
He's like, let's go
Yeah,
back to
I'm
law
not able
school.
to, I can't right in this moment give you that case. I'd be happy to look into that and submit it as a supplemental authority.
You need to
If
tag
it
in
is
Weinberg.
As applied, that would put your client's claim, at least as it relates to within the state of Idaho, as not being problematic, given that he's from one of the smallest districts in the state.
Well, then I want to go back and
She
talk to you,
sensed
Judge,
it. She's
about
like, danger,
the-
danger, danger, danger. Back up. Did you see the reverse? It was like, well, let's, Your Honor, let's go this way, which takes time in the moment. The court is asking difficult questions and questions outside of what the defense briefed on. So she's like, wait, let's go back over here, Your Honor. But the judge is not going to let that go and is asking very, very direct and pointed questions and is clearly incredibly well versed on this.
premise in Hairston, which was pre the Capital Defense Fund, which also has created, in time, another dynamic of whether or not someone's charged with the death penalty and those costs at the time that he was charged. I mean, now it's different. So yeah, I'm not going to concede that as applied, it just simply doesn't fit. I think that there are greater questions than that, but I don't have a case to point you to exactly. I don't think that has been, it hasn't been raised in Idaho. We're making the first equal protection. In other district court cases in North Idaho, Mr. Logston has raised this issue. So I don't want to say
Rejected
you're the
those,
first.
all of those.
Right. But it hasn't.
I'm not surprised that Mr. Logston has raised those issues. I'm pretty sure that this is something that he focuses on because he did a lot of the filings earlier on in this case. Mr. Logston brought us back to the Magna Carta earlier and the field codes of how we got to what a indictment was in Idaho. So there are specialty areas where lawyers focus on things. So I'm not surprised that Mr. Logston has filed similar arguments in other cases elsewhere in the state. And the court's like, right, but also denied in all those cases.
Made it to the Idaho Supreme Court, to the appellate courts.
I just don't see how, as applied, you've provided the court any information where I could conclude that because your client is from one of the geographic districts you claim is the does not get its fair share of capital cases.
And we did not submit that argument in our brief.
Right then.
All right. Thank you. I think you've used your time.
And we're done. The judge, counsel, this should be brief. The judge, when you're winning, talk less, Your Honor. When you're winning, no, counsel, when you're winning, talk less.
Thank you, Judge. I'll try and keep this brief. I think there are two problems in
I'll try to keep this brief. As the court just said, reiterate to the court what he said, give 2 other sentences, and done.
independent problems with the theory that the defense is articulating here, and they both come from Idaho Supreme Court decisions. The first, as this court has noted, comes from Hairston, where the court said, this just isn't how you do the analysis. You don't cumulate them and then do
What's
the analysis.
intellectually wrong with that analysis, though?
With cumulating and then,
I mean, I understand the legal cases may not be supportive of the defense's claim, but from an intellectual analysis, if the point is to make the death penalty less arbitrary,
correct.
why wouldn't you look at the net or the cumulative as opposed to each individual compared on its own in isolation?
An equally tough
So,
questioning
Your
to
Honor,
the
I think
state.
to answer that question,
Right.
you know, looking back to kind of how this was developed with the aggravating factors, the idea behind the aggravating factors is that you have to be able to show that this person is morally worthy of the death penalty. And so if you have individually analyzed every single factor and every single one you found constitutional, then it doesn't matter if in every case you could apply one of those factors, because that factor is a reason why that person is morally worthy of the death penalty. And so it's not an arbitrary and capricious system. It's not left to the whims of somebody. It's
But if you have so many aggravators that on the whole would essentially apply to any first degree murder, then isn't it just left essentially to the prosecutor as to which cases are or are not worthy to bring as a
Interesting.
capital case?
So absolutely, the prosecutor would have a lot of discretion in that. I don't know that I agree with the characterization that it's left to the prosecutor, because of course the prosecutor has to prove that aggravating factor beyond a reasonable doubt. And if they can prove
you have to
one of those
file it,
aggravating factors
And you
beyond a
choose to
reasonable
file
doubt
it.
to the jury, and the jury finds that, then that person is now worthy of the death penalty.
Eligible.
And
I think
again,
is
you know,
the
when we
right
instruct the jury, we don't instruct
choice.
them to consider all
Eligible.
of the aggravators in the aggregate. We tell them you have to consider them individually. We tell the state's required to present non-duplicative evidence for each aggravator that it's going to assert. It can't just throw out a blanket of aggravators. I think focusing on single aggravators is consistent from beginning to end of our entire system. And so I don't see a problem with that analysis that the Idaho Supreme Court said that that's not how you do this. And I would note, I think the court has mentioned this as well, it's not just the Idaho Supreme Court. There are many courts who have rejected this approach. The defense hasn't been able to point to a single court in any state, in any jurisdiction, that has used this cumulative approach to attack the death penalty or the statutory scheme of the death penalty in any state. So I think the court was right in Hairston. Clearly, it's binding precedent. You know, the defense in their reply brief, they tried to say their response to Hairston was, well, that was when judges were doing the determination. And I just don't see the relevance to that, logical or otherwise, how that would matter on the narrowing part. They point to Hidalgo, which they brought up multiple times today, which is a dissent. It has no binding authority. It has no effect whatsoever on the case. So they just can't point to anything to say that Hairston doesn't apply today. It does apply today. And the Idaho Supreme Court has rejected that approach. So that's the first reason why this fails. But then even independent of that, there's a second reason. And that is the defense is relying on this narrowing process that has been described by the United States Supreme Court. I believe the most recent case that they've kind of walked through that was the Tulipa case. And in Hall, our Idaho Supreme Court talked about Tulipa and exactly what that test requires. And they were analyzing a single aggravator because that's how you do this. And it was, the court acknowledged that, yes, this would apply to many, many murders, but it doesn't apply to every murder. And that's all that Tulipa requires. So the way, even if it were appropriate to aggregate all of these circumstances, the appropriate narrowing question is, does it literally apply to every single murder? And even Professor Cover's analysis shows it doesn't. It's a high percentage, but it's not 100%. And so it would pass the narrowing requirements of TULIPA as interpreted by the Idaho Supreme Court, even if it were proper to aggregate these together. Your Honor, in terms of the equal protection claim on geography, I think, here again, they run into a problem with the Idaho Supreme Court. A similar claim based on geography was raised in Hairston, and the court rejected it. The court not only rejected it, the court instructed future defendants, if you want to bring this claim, here's what we're going to need to see. And they said, in order to show that the imposition of the death penalty in Idaho is arbitrary and capricious, there must be some empirical evidence connecting the discrepancy that appears to be shown by Dr. Jensen's study and one or more impermissible factors. And the defense has been aware of that, and instead they bring a study where the person who conducted the study acknowledges, I can't show that. That it's just not sufficient. It's not sufficient to make any kind of, at best, they've shown a statistical discrepancy, and that is not sufficient to claim some kind of constitutional violation, any kind of constitutional violation. I want to end just by talking a little bit about the court's question on, would you have to look at the data up to today? I think the question or the answer to that has to be yes, absolutely. There's no reason why the date Professor Cover conducted her study has any legal relevance or significance. It would be up through today. And I think this goes back to a problem of this whole accumulating the aggregating factors and then doing a mathematical study and finding a percentage, because let's say that courts engage in that conduct, and let's say the courts decide it's 50% is the magic number, and if you get above 50%, then your statutory scheme's unconstitutional. Well, what if Idaho is right at 50.5%, so it's unconstitutional, but then over the next year, a bunch of murders are committed and none of them satisfy the aggravating factors. So now we're 49.5%. Now everyone in that year can be subject to the death penalty because the murderers that committed murders that year decided to do it in a way that didn't satisfy one of the aggravating factors. I don't think there's a logical basis for that. And I think that's why the Idaho Supreme Court has taken the approach they have, where this isn't a quantitative analysis, it's a qualitative one. Is there any narrowing that's being done? And if the answer is yes, then you've passed the test. That keeps things fair and uniform across the state and temporally across time. And so I think that's another reason why it wouldn't make sense to aggregate.
Yes, he just argued it.
Unless there are any questions, we'd ask them.
Fair across time and space.
Address the geography issue?
Yes, Your Honor, I addressed it briefly. I'm happy to talk about it more from the Hairston decision.
It's not necessarily a requirement you do, so I just wanted to know, you were fairly summary about it. And it seemed to me the defense had raised some issues.
He was summary about it and then said, do you have any more you would like to ask? And the court's like, yes, I do. There are two prongs of this argument. He's getting into the second prong. The first prong is that the defense is arguing that the court should strike the death penalty in this case because it is overly broad. So if every case counts as a DP case, then it is too overly broad and then it is unconstitutional. So they're arguing that if you take all the different potential aggravators together in Idaho, then it applies to every single case. The prosecution is saying, first, that's not the analysis. You look at them one by one. Second, even if you take all the aggravators available in Idaho, cumulatively, it still narrows out that not every case would qualify. So that's what they are trying to narrow down. And now they're moving on to the second part of that argument. And the court has pointed out that the courts here have already taken that up. So even if there are multiple aggravators that are cumulative, each aggravator has to be evaluated separately.
That perhaps were a little more expansive than what they had argued in their brief. And so
I would certainly agree with that, Your Honor. So a couple of things on that. First, the idea that it somehow violates equal protection for Idaho to apply the death penalty when other states do not on a national basis. I'm not aware of any case law that would support that. And in fact, it's directly contrary to the case law that we're going to talk about later on evolving standards of decency, where the U.S. Supreme Court has specifically acknowledged that, yes, there are some states that apply it and some states that do not. The conclusion from that isn't that just because there are some states that do not apply it, it's unconstitutional everywhere. So I don't think that that's an appropriate question. In terms of within the state of Idaho, I think to the court's point, with an equal protection analysis, really the first question you have to ask is, who are we talking about and what status do they have or what position do they hold? Because a critical part of the equal protection analysis is you have to treat people that are similarly situated the same. You don't have to treat people who are not similarly situated the same. So that initial determination of are they similarly situated requires a subject, a person. And so to the court's point, I think in the vast majority of cases, at least that I'm aware of, equal protection is raised as an as-applied challenge, as applied to the person bringing the challenge. And so in this case, where they're trying to argue that it's only the larger counties that seek these things, as the court pointed out, that's not true in recent Idaho history. And they, again, have not pointed to any study, Professor Covers or anywhere else, that shows that the reason why there are more death penalty cases brought in the larger counties is because of some unconstitutional reason, rather than, could it be explained by something else, like the fact that they are more appropriate in those areas. And frankly, the common sense understanding would be that you're probably going to see more death penalty cases in more populated areas, because just as a matter of statistics, there's probably going to be more first-degree murders committed there, and therefore probably more that are eligible for the death penalty. So certainly they would have to rebut that with some kind of evidence that shows, as the Idaho Supreme Court told them they had to in Hairston, that makes a direct connection between empirical evidence and some impermissible factor. And that's just missing here. Unless the court has any other questions. Thank you, Your Honor.
Rebuttal?
Judge, I just wanted to touch on the issue that he raised about Harrison and the timing of that, and the fact that at that time when that came down, judges were doing the imposition of death penalty sentencing. And that really is a very important distinction, because as you know, the arguments that are coming up in other motions, the difference in an experienced judge being able to get into all of these nuanced areas and apply beyond a reasonable doubt in the gateway phase, and then just mercy in the mitigation phase is very, very different than a jury's ability to do those things when it's the only case that they're looking at. So I do think it's important to take into consideration the timing of where we're at now with the jury decision. The other thing is, I just wanted to point out some of that mitigating language that I'd referenced in Tulepa that's in the statute that we don't have. Whether or not the offense was committed while the defendant was under the influence of extreme mental or emotional disturbance. Clearly not something that's in Idaho's aggravating statute to consider. Whether or not the victim was a participant in the defendant's homicidal conduct or consented to the homicidal act. Whether or not the offense was committed under circumstances which the defendant reasonably believed to a moral justification or extenuation for his conduct. A statute that, frankly, those types of terms in our statute would be very welcomed. And I wanted to also point out that the study dates
too, right?
amount to between.
We would welcome these changes. Anyone listening, we would welcome these changes, Your Honor. We are amenable to these changes. We would like these changes to happen. And the court's like, well, maybe not. I saw some of you saying, are we on sir, rebuttal? No, we moved to different motions. So they finished the last one on the expert. The expert's not testifying. Then she started the motion on this, the opposition, now the reply. Then we're going to jump to another motion. It is going to be motion after motion after motion, but they're all intertwined. So a lot of the arguments will also be intertwined.
75 and 95, those years in Hairston, in 2002 and 2019 for Professor Covers, that's 37 years worth of data with the same definitions. So, instruction in a few more years of data, you've got 37 years to rely on, that there's no narrowing. Thank you.
you know what year the Capital Defense Fund was established?
It was after 95. And I think that Hairston may have been the impotence for that. If Mr. Logston was here, he'll be here later. I think he knows the exact year of that. But I don't. I just know it was
Has that
after
mitigated the
95.
issue in your mind?
Pardon?
Has that mitigated the issue in your mind?
No, I think that it has not. It has not. And I frankly think that the new system with the state public defense is going to make it worse. I think that there will be no
Okay.
reason for the state not to charge death in every first degree case. Because our statute doesn't prevent them from. Everybody fits. Everybody fits.
Thank you.
And that's the heart of her argument, is that every first degree murder
We'll
fits.
take the issue under advisement and
That's
issue a
going to be
written
under
opinion.
submission.
It's 10:30. I'm going to take a 10-minute break. And we adjourn after that.
I'm going to make a note real quick that that argument is under submission with regard to arbitrariness. And then they're going to go to the aggravators. I just want to make sure I'm keeping track of the different motions because they've moved through them quickly. We're going to zoom because we've got room to zoom. I love, by the way, that Ada County has their like court holding screen and the whole 9 yards. The court has, this county has sorted it out. Look, they've got their handle at the bottom. They've said everything short of like and subscribe and do the YouTube things. I like the layout of this courtroom. I think it's very easy to see. It's easy to hear. They've done a really good job. So when the defense asks to change venue, I think at
I
least
mean, there'll be
for our purposes, is it has made things easier
We'll
to
give, each
access.
side 25 minutes and you can address.
All right, so we are back. I want to hear what the court says as he goes on the record. We are back from the morning break. Let us go. I know, yes, even though we're in Idaho, the audio is not via potato, and I appreciate it. I like the way this judge asks questions. I like that he tailors the argument
All
down.
right, I think
He's read the
are on
briefing.
Now the motion to strike
The aggravators.
individual statutory aggravators. I will give each side 25 minutes and you can address them
He's like, and you're on the
in
clock.
whatever proportion you like within that.
So the defense is moving to strike each of the individual aggravators or the special circumstances that
Okay,
the state
Judge,
has
I
filed
will be
notice of.
covering heinous, atrocious, and cruel, utter disregard. And then I will do multi-murders and Ms. Taylor will do future dangerous. So I'll basically do the next three. And given
Interesting
the
that they
time
call
you
it.
asked, I'm assuming there will be less questions.
I will try to restrain my
Your Honor, you've given us 25 minutes. I assume that the court will interrupt us less.
curiosity.
Right. I'm happy to engage with you.
I, as you know, I gave you some additional time, and that says why.
Right,
Why?
thank you. We are asking that the court strike the aggravator, especially heinous, atrocious, and cruel, manifesting extreme depravity. And I want to focus, I think I just want to start really focused on how this is different than Hall. You know, we're aware that Hall, Arabay versus Levitt, there's a lot of discussion about having addressed this aggravator before. We are framing it for you in our argument in a different way. And so what I want to show are the distinctions is that, you know, Hall was, a decision was issued in 2018, so was Hidalgo. So when Hall issued their decision, the arguments hadn't been framed in light of what we just argued about Hidalgo and that eligibility narrowing. Also, there was no equal protection argument, no argument regarding Article 2, Section 1 of the Idaho Constitution. One of the cruxes of this argument is that what the Idaho Supreme Court and the Idaho courts do with this aggravator is they've created a jury instruction that is construction. construction, also known as, and called in our briefing, judicial gloss. Our argument is that Osborne is from 1981. That's when the judicial gloss was applied, and then recently, the Idaho Supreme Court adopted and adopted instructions related to this. But what happened in 2011 is that the Idaho Supreme Court issued the Verska versus St. Alphonsus decision, and in that decision, the court said, "This court has consistently adhered to the primary canon of statutory construction that where the language of the statute is unambiguous, the clear expressed intent of the legislature must be given effect, and there is no occasion for construction." And the courts have not taken that into consideration. So if the statute is unambiguous, then it should be given its direct meaning, which we quoted in our brief, would be heinous means utterly odious or wicked, atrocious means horrifying, wicked, and cruel means willfully causing pain or suffering to others or feeling no concern about it. And if it is ambiguous, then under Verska, the judicial gloss should not be allowed.
If it is ambiguous?
If it's unambiguous, then the judicial gloss should not be allowed. But what, the state is arguing that it is, has not argued that it's an ambiguous statute, because that would give us grounds for the argument that it should be stricken from as an aggravator, as arbitrary and capricious. And so we are asking that you take into consideration the way that we are framing this argument, which is different than it was
Between
in Hall.
ambiguous and vague.
Pardon?
What's the difference between ambiguous and vague?
I don't know that I can necessarily draw just a distinction there. I think that they're,
That's fair,
similar.
counsel.
Yeah.
Would you say synonymous?
Well, so let's do all of yours,
Yep.
and then we'll do all of theirs. I think it goes faster that way. If we do this
Yeah,
back and
stop
forth,
walking back and
I think
forth.
It takes longer.
Yep.
They can take notes.
I agree with the court, by the way. Let the defense argue all their motions a lot of the motions are incredibly similar on similar grounds.
So
And
utter
then let the state
disregard
respond at the end.
falls under the same argument. The one thing that I want to point out about utter disregard is that Idaho is the only state that has that as an aggravator. But when you look at other states, there's language that is found that is the same as heinous, atrocious, and cruel, which is interesting because it looks like almost we have the same
Duplicative.
aggravator labeled as
Two
two
things.
different things. And we also raised the argument there that it's a separation of powers violation when there is construction on that statute.
And the argument here is that there's an aggravator that the crime was, and again, the jury has to find all of these. They're trying to strike them because if you strike all the aggravators, then we don't end up in a penalty phase because it's not a decision that will be made by the jury. The jury will have to find all these things if there is a conviction, if it goes to a penalty phase. But the argument is that the last aggravator, which they have referred to as HAC, the heinous, atrocious, or cruel, the end of that is manifesting exceptional depravity. The argument here is that the utter disregard is so similar to the exceptional depravity that you now have overlapping aggravators for the same thing, which is why they were saying with all of these aggravators, every case could count, because you could argue that any case could count, showing that there's an utter disregard for human life in a murder case. So the argument is that the utter disregard for human life, well, any first degree murder could be that. So therefore it is overbroad and too vague. So, and also maybe subsumed into the other one. But even if you strike this aggravator, the other aggravators will be found. But again, this is all arguing without the facts of the case coming in. So this is arguing in advance. But I understand them saying, isn't exceptional depravity and an utter disregard for human life kind of the same thing? So that's why we're arguing this one. She's also going to argue some of the other aggravators that have been filed. The state files all the aggravators on what they think the evidence will show. And then this can also still be narrowed down the road. If the court gets rid of all the aggravators, which is exceedingly unlikely, then there would not be a penalty phase. Continuing on, hopefully that made it clear.
Statute, and that violates VRSCA. The next one that I am going to cover is the multi-victims aggravator.
Most states have a multi-victim.
Idaho is the only state that has both a multi-victim and propensity aggravator. A multi-victim aggravator is clear. We were having that discussion between clear and fuzzy. Multi-aggravator is clear. 1 + 1 equals 2.
Equals multi.
The irony in some of that is that it seems to lessen the value of a single human life, but it still doesn't tell us anything about the culpability of the person who has been charged with the crime.
Well, isn't it more culpable to kill 2 people than 1?
I think that the issue is, the problem is that it is.
Isn't it a morally more problematic, the number of lives you take?
I think that it depends on, first of all, I want to start answering that question by saying any life taken.
I agree. And
Right.
Right.
Um,
And the
but-
floor is pretty high. But what I'm saying, doesn't that bring you above the floor?
I think that it depends on the underlying facts of what is the result, what's the
Which is
basis of
why-
how multiple occurs.
Which is why
and-
the state has the ability to choose to file an aggravator or choose not to file an aggravator. That's where the specific facts come in.
And so just to say that the number of people relates to culpability, I think that what the argument that we're making is that supports the other aggravator of propensity. And under Idaho's, the method of selection with a jury and the rules about double counting, while the jury can take into consideration the same facts for multiple aggravators, there must be more than one fact per aggravator so that there's not double counting. And that is the problem when you've got a multi victim aggravator and you also have a propensity aggravator. And there's been, as we cited.
Is that a constitutional problem or an evidence problem?
It becomes a Eighth Amendment constitutional problem when a jury has an inability to properly distinguish between those issues in finding aggravators beyond a reasonable doubt.
But that could be
As
fact
the
specific.
gatekeeper, I assume that if the state hasn't provided additional evidence that would support propensity that is not included within the multiple murders, then that aggravator wouldn't go to the jury, right?
Well, I mean, we would hope that the gatekeeper would do that. Yes, Judge, we're asking you to be the gatekeeper now and prevent us from even getting to that question because of the problem that is identified. And
the judge is saying if the evidence doesn't bear that out at trial, it can be stricken then. So if at trial in the guilt phase, that's not borne out, then it wouldn't even go to the jury because you would strike it at that time.
provided the court with law review articles where the issue has been studied about how impactful multi-victim facts are into the ultimate decision regarding aggravators. I also wanted to point out that there are multiple states with a multiple out of aggravate that have that multi-aggravator, but they don't have future dangerousness, which Ms. Taylor will talk about, and that is very related to
It's fairly
propensity. And those states are
fact-specific, though.
Alabama, California, Kansas, Montana, Tennessee, and Utah. And in fact, Texas is a good example of, it's a part of the definition of capital crime, and then the jury has to decide on the aggravator of propensity after that has been included as part of the narrowing in the Texas statute. So for those reasons, we'd ask that you strike the multiple aggravator as well.
So we've gone through three of them.
Your Honor, we're asking the court to strike the aggravator of future dangerousness or propensity, whichever label we want to put on it, but it's found in subsection I of 1925-19, subsection 9. And I think when we're thinking about the
I
constitutional
think that's a fact.
way this is laid out
though.
to be protective of the Eighth Amendment, to have a true narrowing, and it can't be vague. We've been talking about that all day, so I won't go into that again. But with that in mind, I want to read the words of this aggravator for the court. That the defendant, by his conduct, whether such conduct was before, during, or after the commission of the murder at hand, has exhibited a propensity to commit murder, which will probably constitute a continuing threat to society. That language does nothing to narrow. That, I'll skip right to the vague part of the argument. We're asking the court to consider three things in striking this aggravator. It isn't narrow, it's very vague, and it doesn't go to the culpability of the crime that's been charged and, if this happens, convicted of. Your Honor, this language, I think, has been acknowledged by our Idaho Supreme Court as needing the gloss in Creech. And I would say that what's required is that the statute, which Idaho doesn't have, has to provide the narrowing or the sentencing structure, and those things are legislative processes. And that hasn't happened. We have the gloss from the Supreme Court. The gloss that the Supreme Court has put on this, though, does not do anything but loop us back to the statutes that define murder and then exclude
there's-
voluntary manslaughter.
And she's saying there's not a statute that addresses
If
this.
truly we are to have an aggravator that selects out the worst of people who have been convicted of murder, this does not do that. The language in this aggravator is incredibly vague. When you think about really what is going to happen in front of a jury,
specific.
they're going to get all this evidence that is supposed to be proven beyond a reasonable doubt. I trust the court will instruct them on that.
Well,
But
he
then they
has
get
to.
this evidence that probably will make them believe that person's a future danger. The chance for a jury to misunderstand the call and the burden that needs to happen is really great by the language alone. And Creech really doesn't do anything to help. The gloss that gets put on, the jury instruction that gets put on, that doesn't help. That just says
Did
people,
Hall say that it was okay? I can't remember if they addressed that in Hall. I think they
I think
did.
Hall did say it was okay.
So what am I to do about that?
You are to listen
Fair
to that.
point, Your Honor. What
allow
am
me
I to do
make my
about that?
record, which I am, but you were to say, nobody else has talked to me about the real language in here when it says
If the court says
probably.
it's okay.
That is confusing to a jury. This isn't a judge's call any longer, but this is confusing to a jury to have those words in there. And the chance to find this aggravator, either based on one of the other aggravators, which we know cannot happen, or at a lesser burden because of the word probably, you're to find that is way too vague. And you should strike this aggravator because of that.
That's what she wants you to do
Additionally, while
about
we're
it, Your
talking
Honor.
about vague, there's a lot of potential for the jury to misuse mitigating factors and make them into future dangerousness aggravators. And
That's a good
Isn't that
argument.
the truth?
The possibility always in sentencing? I mean, one man's aggravator is another man's mitigator. And I think you
I think
pointed
that's
out
a
well
fair
in your
argument.
brief of mental health, right?
Mhm.
But isn't that the nature of individualized sentencing and the consideration of those factors?
I think it is a danger. And I can't square in my mind how I am to do my ethical duty to my client and to abide by the guidelines that are set forth in capital cases and do an investigation into mental health and then turn it over like Idaho says I must, and then subject my client to
Having
the
it used
state's
against them.
expert to grill him for however long. I mean, I have this duty. My client has the right to present this. But now I have to do all of this and give all of that information up so the state can use it in an aggravator that says, just tell me that the person will probably be dangerous in the future. That is just terrible, Judge. And for that reason alone, you should strike this aggravator. The last comment I'll make is that future dangerousness doesn't go to the conduct, the culpability of the conduct that has happened. And that's really what these aggravators need to do to narrow properly the scope of who's who. I can't tell you the number of times I've sat in court and listened to a prosecutor talk about at sentencing that my client or my client's acts are the worst they've ever seen. And that can't be true when you sit in court day after day after day and you hear that about
Yeah, those
person
are
after person. after
heavy words
person.
that should be reserved.
This statute
judiciously.
doesn't do anything to help a jury decide who's the worst of the worst. This aggravator absolutely has to be struck. It's a violation of the Eighth Amendment.
Thank you.
And now we're going to get to the state's opposition to the 4 defense motions to strike the aggravators in this case. So this is the prosecution arguing in opposition to the motion to strike the 4 aggravators. Future dangerousness, HIC, multiple victim,
Your
and
Honor,
utter disregard.
Beginning with the heinous and atrocious and cruel. This aggravator specifically has been upheld by the Idaho Supreme Court, and specifically the judicial gloss placed on this aggravator in Osborne.
Was
Now-
Hall a jury determination? Do you know?
I'm not sure on that, Your Honor, off the top of my head. I apologize.
I think it was, but I don't recall specifically. Notwithstanding the fact that I think that I'm the actual judge on the case now, I don't recall it, because that issue hasn't come up, but.
Thank you, Your Honor.
That's funny.
And I apologize.
He interrupted you. Don't apologize, ma'am.
The defendant has raised this argument that in Verska, the Idaho Supreme Court's decision stating that the court would not rewrite or void an unambiguous statute is essentially the same thing as stating that the Idaho Supreme Court is saying that we can't put a gloss on a statute. But those two things are very different, because placing a gloss on a statute to ensure its constitutionality is not the same as rewriting or voiding a statute. If Verska is taken to that extreme, then courts can't interpret statutes at all. And that's not the holding of Verska. Verska simply stood for the proposition that the court was declining to rewrite or void a statute. And of course,
For those of
The
you
Idaho
asking
Supreme-
about what a judicial gloss is, that was what she was just arguing to the court, that if a statute taken in its most literal sense may be unconstitutional or may be violative, the courts are allowed to interpret it to say this statute means this in its sense, even if the most literal context might run afoul. Different than them striking down the statute, or different than them striking out parts of a statute. So getting to how judicial interpretation works is what they are talking about with, does a statute work, or does it get struck down, or does the court interpret it? So that's the judicial interpretation of the thing is what they're referring to as the judicial gloss of of the statute and of the thing, saying that, look, a lot of people in the legislature are not lawyers. So there are times that the legislature will do things that the judicial branch is like, what? How? Rules. And so it depends on where that line is and how close it is to being okay as to how the courts interpret it. So that is what they are getting into with that argument of, but if the statute's only okay if the courts have to do gymnastics to interpret it, then shouldn't it be struck down and rewritten? So that is a very much larger conversation about how judges are to interpret laws, when they are to strike laws down and say, go back and try again, when they are to try to make laws work, understanding that striking down a statute can leave it years before it can get done again, et cetera, et cetera. These are large conversations, and they are being had in courts like this to try to determine what is the right way to address it. So that is what she just explained. Let us continue.
The court has never rewritten the heinous, atrocious, and cruel aggravator or the utter disregard aggravator or any of these
And she's saying
aggravators.
these have
They've
already
simply placed a
withheld
judicial clause.
and withstood scrutiny
As to
with the interpretation by the courts.
future dangerousness and propensity one, which was the most recently addressed, that too has been upheld by the Idaho Supreme Court in State versus Creech. The propriety of considering future dangerousness has been upheld by the United States Supreme Court in Jurek versus Texas. In their propensity argument, their future dangerous argument, the defendant is essentially asking this court to start with a proposition that a jury is not going to be able to follow the court's instructions.
Yes.
And of course, we can't start with that proposition because juries are presumed under Idaho law to follow the instructions that they're given. And that is another issue, that issue is also true in the defense's multiple victims argument. Their argument with multiple victims really doesn't cite to any case law. It's simply based on the fact that they're assuming that a jury
Multiple
is
victims
unable to
one of the
distinguish
most
between
common
propensity and
aggravators.
multiple victims. And again, the court is being asked to start with the presumption that a jury won't be able to follow the law. And that's contrary to the state of the law. We can't presume that because juries are presumed to follow the law. Additionally, we also can't start with the presumption that the state is going to just put on the same evidence for all these aggravators. The court should also assume that the state will put on independent bases for each of these aggravators during the penalty phase. That's our legal obligation. And the jury will be instructed as to what the law is. They will be instructed that they can't double weigh or double count. That's very clear in the case law. The state would just ask that the court decline to presume that the state will present the evidence in a way that's contrary to law and that the jurors then won't follow the instructions. That can't be, Your Honor. So the state would ask the court to deny the defendant's motion as to these aggravators. All of these aggravators have been upheld, specifically the hack along with utter disregard and future dangerousness. There is case law directly on point that is binding on this court. We would ask the court to deny their motion.
Thank you.
So the conversations that they are having
Judge, to answer your
are
question about Hall,
about this case, but also larger conversations than this case, are these statutes, because none of this gets applied until after trial, if there's a conviction, if this case continues to move forward as a death penalty case, which even though it's filed at the beginning, doesn't mean it's going to get to the jury at the end. It's like if, then. The arguments that are happening here today are, but even if, are these things constitutional? Can these things go forward? Should they be stricken out? So it is arguing whether or not these statutes and findings in laws should apply, or should they not apply at all moving forward? And so it is a conversation about this case, but it's also a much larger conversation about whether each individual aggravator in the state of Idaho is constitutionally sound, can be applied, or should be stricken. So it's doing two things at once, but these are conversations, A, that have to happen, and B, evaluate what the case law is doing, what it's seeing, how it's being applied, whether or not the case law is sound, whether or not it applies in this case. So it is it is a conversation about this case, and it's a conversation about the state of the law in this area of law in totality.
Hall was originally sentenced by a judge, and then the sentencing was retried, and Mr. Chastain and Ms. Christensen handled that case.
My memory came back to me between then and now, so thank you for clarifying that.
Yeah.
Your Honor, that's what happens with the chat. I'm going to start saying it that way. My memory has come back to me. No, it's just chat. Chat has reminded me, but the court can't just be like, chat, what about this? But it's like my memory has come back to me.
I want to point out that Verska says, if it's socially or economically unsound, the power to correct is the legislatures, not the judiciaries. If it needs fixed with construction, as we argue that it does, it must be stricken. And I want to address the question that you asked about why not wait until the evidence comes in and I can strike the aggravator at that time. It goes to the point of why we are arguing all of these right now. There's a huge difference between picking a death qualified jury and a non-capital qualified jury.
Well, but that just went to my point of your argument presumes I would strike all of them. If,
Yes.
for example, I were just looking at
Yes.
multiple murders versus propensity, and those two so overlap that you can't have both. You could still have one, or you could have both. But if there's not evidence independent of one, then
It's
you
moot.
would strike the one.
So you're correct that we are asking you to strike all of them so that we don't
And the
have.
court's like, you're assuming I'm going to strike them all. However, there are aggravators here that have withstood test and scrutiny at all levels of the courts. So those are not going to be stricken. So the court is essentially asking, well, if you aren't striking all the aggravators, then isn't it too early to argue over specific aggravators? Because if there is one aggravator, then they need to prepare the case as if it is a capital case, and they need to find a capital qualified jury, and they need to prepare a penalty phase. And the court is saying, so if that's true, because some of these are going to be upheld, like the multiple victim aggravator, so that's not going to be struck. So then when we're looking at some of these others, don't we have a conversation about this after the evidence comes in, if there is a conviction, and then see if those should be stricken and narrow down what the jury will consider down the road? So that's a back and forth where the court is saying, you want me to get rid of all of them? That's unlikely. And then where do we go from here? And the defense is saying, well, picking a jury in a case like this comes with its own set of complications. So yes, we don't want you to strike all of them.
Have to pick a death qualified jury.
You're going to have to do that
because death
anyway.
qualified juries are highly likely to convict in the guilt innocence phase. So we are very, very concerned about that, and the fact that that is so different in a death penalty case.
I think it's hard. This is their argument. I think it is hard to conflate the two things. They are saying if prosecutorial restraint is what it is across the country, and I have deep questions based on some of the cases that we have seen, but those are not DP cases. But once you get a qualified jury, which is a much more intensive and longer jury selection, once you ask all of the things and go through a much more rigorous voir dire, and then they see all the facts, if it's true that juries are only being presented with the worst of the worst cases for a penalty phase, then it does not surprise me if they've already found guilt that that same jury who has seen the cases that are the worst of the worst and have sat through that case then decide whether or not to impose life or death. So I don't know if it's fair to say, well, the jury is somehow prejudiced or predisposed to that penalty because of the voir dire, when my argument would be, and again, I come at it from the perspective of a prosecutor, my perspective on that would be that a jury is waiting to see the facts. And once they have seen all the facts of the case is what changes their mind. If prosecutorial discretion really only puts forward in every jurisdiction the worst cases that exist. So she is trying to say, Your Honor, no, this jury could be predisposed, and then they could be predisposed to guilt because of the way voir dire is happening, because that is her argument.
But to the extent that you might strike some and save one, for example, the multi aggravator, there's a vast difference in what happens in front of the jury in the selection phase with that aggravator versus the others that we are asking you to strike. Thank you.
Thank you.
Your Honor, I certainly didn't mean to tell the court that I would presume whatever jury we end up with won't follow the law. What I'm saying is that that particular statute, the future dangerousness statute, is really tricky. It's tricky because of the use of the word probably. It's tricky with the rest of the wording too, and based on the information that will likely come in. I point out that when it was up to a judge to decide, I think a judge is well versed in what does beyond a reasonable doubt mean and what is a probability. The court looks at that all day, every day, and those are hard concepts for a judge.
Standard would be that the jury would have to be convinced beyond a reasonable doubt that it is probable that the defendant would be likely, or is probable that they would kill again. I think is the way that washes
And
out.
I think there are
I think
cases.
that's the way it washes out too. And I think it's just a problem with the word probably in there. So when a judge was doing this, it was less of a problem, but I still think there's issues with that particular aggravator. And I would
And
point
she's saying
out
when a judge made the determination on sentencing versus a jury making the determination on sentencing. I understand their room to argue here, because how does anyone determine what somebody's probability is to commit future crime? Her argument earlier was, if we need to present things that mitigate, show the circumstance of a human, show their background, show any mental health struggles, how do we know a jury won't turn around and use that against them and say, see, because of this, then they are likely to do that? But I think the facts of a particular case bear out quite a lot here. And the facts of a particular case can be very narrow, or they can be more broad. It really is factually specific. And what the court said here is, if the facts don't bear it out, it can be stricken before it goes to the jury. But I understand her argument on this particular propensity argument. Not all jurisdictions have or allow this argument. And if it has to be beyond a reasonable doubt, how do you find beyond a reasonable doubt? Probably. And do you base someone's life on beyond a reasonable doubt? It's probably true. Is that internally inconsistent? And so on all of the aggravators that they're arguing, I can understand the difficulty in this particular aggravator, because yeah, that is difficult. How do you reconcile those two things?
The higher courts in Idaho have recognized the problem. That's why the decision in Creech put a gloss on it. And I think when the courts recognize that that's a problem and there needs to be a gloss or a fix put to it,
It should be
That's one
stricken.
thing for the court to consider. How the
just-
fix was done, I
or
think
strike
is a
it.
problem. It's a jury instruction, not by the legislature. But keep
Kick it and
in
send it
mind,
back,
there's a
right.
problem with this instruction or with this aggravator. It needs to be fixed, but the fix is to loop back to statutes that already exist. And I don't really think that's a fix. And I'll stop there.
That's a fair argument. Your Honor, if the court has to keep fixing this statute, the statute's broken, our client shouldn't suffer because the legislature didn't do it right. They should be told to go back and do it again. So NR in the chat asked, is Bryan Kohberger claiming mental illness? Not as an affirmative defense, but when you get into a penalty phase, if that happens in a given case, that's often something that when the jury looks at aggravation and mitigation that is brought up. And Taylor was arguing earlier, but that becomes a double-edged sword if this is one of the aggravators and what he's using in mitigation, the jury could consider in aggravation, and that puts the defendant in a really difficult position. So that was the argument there.
All right, I think the non-statutory aggravators is the next issue for our attention. So with that, I'll hear from defense.
These are additional.
Thank you, Judge.
So those were the aggravators written into law by the legislature. Now we are getting to non-statutory aggravators, which is interesting to me. A lot of jurisdictions, I don't know all jurisdictions. This is not an area that I have deeply studied because I practiced in a very large jurisdiction where I practiced and understood that jurisdiction very well. But non-statutory aggravators is things that are not written into law by the legislature. So we're going to get into the defense arguing to strike not the things lined out in the statute, but other aggravators.
Your Honor, by way of housekeeping with the non-statutory aggravators, I understood the state's response briefing to say that they agree that they have to provide notice and any discovery about non-statutory aggravators as well.
They said that they would, is what they had
Yes.
said they would.
Yes. So I think I don't have to argue about that. I think I'm limited to arguing about the burden of proof required for non-statutory aggravators.
Arguing for the defense, for the state on that issue.
Yeah, Your Honor, the state's position is that the statute clearly says that Rule 16 applies. We agree Rule 16 applies and we'll comply with Rule 16.
I'll limit my comments then to burden of proof. Your Honor, our position is that
Wise.
non-statutory aggravators need to be proven beyond a reasonable doubt as well. We know that the state can use non-statutory aggravators to help them establish aggravators beyond a reasonable doubt. And looking at the court's new jury instructions that just came out, beyond a reasonable doubt is all over those. When we're talking about aggravators, there's no question there. Those jury instructions are silent on non-statutory aggravators. So I can't lean on
Interesting.
those to say that the court should find that these have to be proven beyond a reasonable doubt. But from a fairness standpoint and from a it just makes sense standpoint, you should say they have to be proven beyond a reasonable doubt. I'm thinking about this in the context of having a jury and having the prosecutor producing evidence and arguing beyond a reasonable doubt, but having these other non-statutory aggravators and say, these are things that we have that you should consider, but we don't have to prove these to you beyond a reasonable doubt. I think there's a real danger in a lack of confidence in the finding of an aggravator if you don't require them to prove the non-statutory aggravators beyond a reasonable doubt, just like their statutory aggravators. Capital cases are a really big deal. And if we're going to get all the way to the end of this, and that's where we're at, the court has to have confidence in what's presented to the jury. Mr. Kohberger has a right, if that's where we end up in his case, to have a jury finding any single aggravator they might find beyond a reasonable doubt. And we think you should order the state to meet that burden if they're going to present non-statutory aggravators.
That was a restrained argument. Most of this motion was about notice, and the state's
Your
like,
Honor,
obviously,
I
we
want to
have to
start by
give
just
notice.
I tried to be very careful in my brief to refer to it as non-statutory aggravating evidence, because I'm not sure what a non-statutory aggravator is. I want to be clear, the state's under no impression that there's some shadow list of aggravators that it can prove one of those and that qualifies the defendant for the death penalty.
Fair.
We are, of course, required to prove beyond a reasonable doubt one of the statutory aggravators. And I think what we're talking about here is just non-statutory aggravating evidence. So evidence that may not be, and if I'm being,
So if you look at it like a scale,
That helps.
and the defense puts on evidence of mitigation, and the state has to put on at a minimum evidence beyond a reasonable doubt of a statutory aggravating evidence. When you go to weigh, does your non-statutory aggravating evidence go on the scale when that weighing is done?
yes, Your Honor. And I think that that's clear from the Hall decision when they talked about this. They talked about they talked about the Zant decision from the United States Supreme Court and how it's important that juries understand when they're making that, when we get to the individualized determination of is death appropriate in this case, it's important that the jury have a wide array of information. That's the purpose of the statute, is what the Idaho Supreme Court said. So yes, I think at that point, any aggravating evidence that has been presented goes on that scale. Now,
Interesting.
to be candid with the court, in my mind, anything that's relevant to a statutory aggravating factor isn't non-statutory aggravating evidence because it's
just
relevant
relevant
to
evidence.
the aggravating factor. And just to be frank, I can't even come up with a good example of what the state would put on in this case that would qualify as not relevant to an aggravating circumstance, but relevant to the overall weighing process.
Right.
I guess my point is, I don't know that this is going to be an issue, given that we will, of course, comply with discovery.
He's
We
like,
will
"There's
provide
rules."
everything that they'll know what we're going to say before we
We'll
say
follow
it.
the rules.
And if there's an issue, we can raise it at that time and discuss, is this actually relevant to a statutory aggravator or not? And if not, does it fit into what I consider to be a very narrow category of non-statutory aggravating evidence that is still somehow relevant to the overall decision, but not one of the
I
aggravators?
think the
But
visual
isn't
using
that-
my scale would be to get
Doesn't
on the
that-
scale.
But doesn't that become a question at the, like a 402 question at the time?
The statutory aggravating evidence would have to have been proven beyond a reasonable doubt, right? That is, you have the existence of that aggravator would have to have been proven beyond a reasonable doubt.
Right. By evidence.
As I understand the non-statutory aggravating evidence, the existence of that evidence would need to be proven only by a preponderance of the evidence. Is that your understanding?
No, that's
You know,
not what
I don't know
said.
that I would completely agree with that, because I don't know that that's laid out in the instructions that it's to any specific burden. I think if you look at the jury instruction 1722 on jury deliberation, it talks about finding the statutory aggravator beyond a reasonable doubt. And then when it gets to weighing, what it says is you must each decide for yourself whether all mitigating factors presented when weighed against each statutory aggravating circumstance proven by the state are sufficiently compelling to make the imposition of the death penalty unjust. You do not have to unanimously agree upon what mitigating circumstances exist. The existence of mitigating factors need not be proven beyond a reasonable doubt. You must each decide for yourself whether mitigating circumstances exist, and if so, then consider them in your individual weighing process.
Right, those are the mitigating.
Correct, but I think what I'm getting at is that's what we have in terms of the instructions of this weighing. Is it's saying to the jurors, you're going to conduct kind of an individual weighing
So you can
process
use
to decide
both.
whether it's just or unjust in this circumstance, and that's the point where these things would come on the scale, to use your analogy. And so I just don't know that there's a point where you would instruct the.
Is there a better analogy in a court of law than scales, though? I don't know. We've sat through a lot of really terrible analogies that I'm not mad at the scales one, because that's, I mean, when the jury has to weigh, really, this is a balance. I'm not mad at that analogy from the court at all.
Jury, you heard from witness X, they said A, B, and C. You can only consider that if you find that A, B, and C is true beyond a reasonable doubt. I don't see an instruction for that anywhere. I don't think that's typically how you do sentencing. They would put on their mitigation. Maybe we have some rebuttal to that mitigation that you might consider non-statutory aggravating. But then again, it specifically tells the jury you do not have to find mitigating beyond a reasonable doubt. So my point is, both in the mitigating evidence and in this non-statutory aggravating evidence, there isn't a standard that's given to the jury. And I think that is what was intended by the instructions. And we could debate whether that's the right call or not, but I think that's what the statute calls for. I think that's what the instructions call for. And I think that's the process that we should follow. Recognizing, of course, this court's role as a gatekeeper as to what gets heard at all. The fact that we'll be complying with the rules of discovery and they can bring up any objections that they want beforehand. I don't know that this will be an issue in the case. Unless there are any other questions, we would ask that you deny the motion. Thank you, Your Honor.
He was walking away before he even finished that sentence. He's like, and we're done.
Your Honor, I would start by saying I thought I heard the state get really close to saying they're not planning to produce any non-statutory aggravators or non-statutory aggravating evidence.
No, they said they're not sure what you even mean by
which
that.
might be really good. It might save the court having to make the decision if they get all the way there. I would say, though, there's
No,
not
they
a
said, what do you
statutory
mean?
list of non-statutory aggravators. But
So what are
in
we
Hall,
talking about? Can we define
it
what
talked
we're talking
about, that decision talked about things in a person's background, if they had a prior criminal history, things about their character. And a prior criminal history, that's fairly definitive. Either you have one or you don't, right? But things about a person's background,
These are
that's where
almost
it gets
402.
really questionable. Are we talking about people's opinions, people that maybe would have an axe to bear with the person that they're talking about? So I think that when you consider what Hall talked about as a non-statutory aggravator, it becomes really important that the state have the burden of proof of beyond a reasonable doubt for those. I would just close by saying that Gardner versus Florida talked about why we have notice and that reliability matters.
And they said
But it's
notice
the
was going to be
same
given.
thing on this kind of information, this kind of evidence, these kind of non-statutory aggravators that get produced. It has to be reliable, and the court has to be able to rely on what a jury comes up with. And Mr. Kohberger has a right to have information come in fairly, to have notice of that information, and for the state
And
to
they
carry the
agreed.
burden. And they need to carry the burden if they want to present non-statutory aggravating evidence.
I think the problem with this motion and the difficulty with this motion is because the evidence is not in and because the defense doesn't have notice yet, because it's too early to have notice, then you're arguing things more broadly than it helps. It's like the state shouldn't be able to put this in. And the state's like, this is what? And the defense is like, this. And so it's this one's a little early. And I think the court's going to say this is a little early. The state has to give notice of what they intend to use. So are we moving on? What's next? They've moved through pretty well today. There's motion to, there's a two more motions to strike and a motion to trifurcate
All right.
left.
You're okay with it. I'm going to swap 8 and 9, just because I could see 8 potentially going a little bit longer than 9. And so,
9 is the trifurcate,
well,
I think.
Your Honor, can I
Yeah.
help on that?
yeah,
If the court takes the first part of 9, the speedy trial issue,
Oh,
that's the one I'm handling. And I think we've got Jay that's ready on the rest of them. We can cover it, but he's really close.
so he's not here. All right, well, let's start then with 8, contemporary standards of decency.
That's the one that Mr. Logston
Oh, he
would
is.
be here.
That's the one we
I've got
can't do
Steve.
yet, Your Honor.
Would you have, who has trifurcation?
Jay is the one that's the most prepared on trifurcation.
So you've got Speedy. Let's start with that.
I can do that.
What
Thank
can
you,
we do
Judge.
now? Where is Jay? Jay! So Mr. Logston is on
Your
the
Honor, we're
way.
asking the court to strike the death penalty in this case based on a
We are now moving on to the next motion. There are 3 sets of motions left. The next motion is, and I'm sure she's going to say it, Emily, keep reading, is the motion to strike based on speedy trial, lack of grand jury, which goes back to Jay's arguments. It feels like 7 years ago. And then also based on international law. So there's and failure to present the aggravators at the grand jury. So they're going to get into like 3 parts of one motion, but the request is still to strike. So that is same request, different grounds.
Conflict of constitutional rights and Mr. Kohberger having to face the choice between holding on to one constitutional right at the expense of another. And that's what's happened here. He has had to choose between his 2 constitutional rights, and those were effective assistance of counsel or speedy trial. Mr. Logston wrote the brief on this, and he did a really good job with the history and why we should look at Idaho's speedy
Magna
trial,
Carta.
constitutional guarantees of speedy trial in the same time frame that the statute 1935-01 says. I'm not going to go into all of that again, because really this is about the choice of picking between constitutional rights.
It seems to not to go into the history that your argument essentially asks the court to equate what the pre-constitutional statutory standards were as then constitutional standards. And I think the court has said that that's not the case. Am I wrong about that?
The court's like, yeah, no.
I'm not sure I'm following what the court's asking me. I'm
So
sorry.
it seems that you're asking the court to equate what the statute said about speedy rights before the Constitution, Idaho Constitution provided for it, and treat that as the constitutional standard and grafting it into the constitutional standard.
That's
I
probably
would
what he's asking. That's probably exactly
say
what
that
Longston
it's
is asking.
there to provide guidance, because there was that the statute we have now
The
is
context.
after the Constitution. The territorial statutes were before we had the Constitution. And when Idaho wrote its Constitution and said, we guarantee defendants a right to a speedy trial, there was that already in mind. I don't think our Constitution says it's 6 months to the day and it's over after that. I don't think that at all. But I think that what was a speedy trial would have influenced a speedy trial right. I do not think our Constitution says it has to be 6 months, but I think our statute does now, and our statute derived from an older statute. And I think that statute, well, I know that statute predated our Constitution, and I think it influenced the writers of the Constitution as a guideline, as a limit. We also know that speedy trial you can go beyond the statutory timeframe, and you can stretch that out in different circumstances for different reasons. And our argument is less about that. That's not the argument. The argument is the choice that Mr. Kohberger faced in August of 2023,
Right, it's a
when
balancing.
he had to choose to continue his case, thereby giving up his speedy trial rights, or go to trial on October 2nd of 2023, 10 months after being charged with this case, with completely unprepared counsel. And that's really the crux of this argument. And the remedy is for the court to strike the death penalty, because Mr. Kohberger had to choose between rights, reinstate Speedy, and reset a sooner trial date. That's the remedy.
What?
I want to talk about what
wait,
happened.
what?
And
Wait, girl, what? Your Honor, Kohberger was forced to waive his speedy trial right because otherwise we could not be prepared on this case. And so what we are asking for today is for you to strike the penalty and then reinstitute his speedy trial right and go to trial sooner. Ma'am, we all sat here as you argued that you could not be ready and that the trial needed to be pushed out, and that the trial needed to be further out, and that you wouldn't be ready when the state said they were ready, and that it needed to be pushed even further, then you changed venue, then you added it needed to be pushed out even further because you needed to swap out an expert, et cetera, et cetera. Ma'am, now you're standing in front of the court saying, strike the penalty and then bump the trial sooner.
And why Mr. Kohberger had to continue his case. The court's already heard a little bit today about the duties of counsel in a capital case and the kinds of investigations we must launch immediately. It's not just about the facts of the case, but it's also about the facts of the case. But the mitigation phase has to be launched. Whether or not you ever end up with a conviction, that work has to be done.
Well, right.
That's the way it works, and it takes the time to do that. You have to find experts, you have to find records, and it takes time to do those things as well. So, and discovery can be a really big deal, and I think the court is probably starting to understand just how big of a deal that is. Last August of 2023, when we were in that place where we had to make that decision. And there was a scheduling order from the prior court in this case that told us you have to continue it by this deadline, by this date, or you can't continue it and you're just going to go to trial. So I think we're positioned a little bit differently when we are truly in a place we have to give up one right to have another right. Had Mr. Kohberger gone to trial and stood on that right, his speedy trial right, and lost his right to effective assistance of counsel, there would have been more than a year's worth of discovery that his counsel would have not been able to know about.
Okay, but
we have continued to get discovery. I think there's a bit more that continues to trickle in even past the deadline. I'm not arguing about that right now, but it's just a vast amount of information that Mr. Kohberger would have not had counsel prepared for.
Well, in the state
We
might
do
not
not
have been prepared
have
for either,
the mitigation
honestly.
investigation completed. We're in process with that still, a year and 2 months after that deadline. So he would not have had that to benefit him either. I think one of the most important things the court should think about when we think about Mr. Kohberger having to choose between his constitutional rights is that we're here right
Thanks, Mr.
now
Langston.
because he couldn't get a fair jury in Latah County. And if we'd gone to trial in October of 2023, he would have maybe held on to his
But
speedy
you
trial
didn't
rights.
need
or he would have
discovery
held
to
on
make
his
that
speedy
motion.
trial rights, but he would have given up his right to effective assistance of counsel and his right to a fair and impartial jury.
But that's a choice.
What's wrong with the idea of speedy evolving on a sort of good cause basis? I mean, capital cases at the time the Constitution was adopted were tried within 6 months, right? The standards of how to try those cases were obviously different.
And they didn't have gigabits of data.
And as more contemporary thoughts about that have arisen, it's become the standard that they require more
Care.
And so why wouldn't Speedy be flexible to accommodate that?
Well, I don't know why it would or why it wouldn't, but that's not been what's happened. We don't have a separate criminal rule that says that. We don't have a separate statute that says that. We would bend the Idaho Constitution until it breaks to make it say that. I'll give you kind of an example. During the time of COVID, when the Supreme Court told the speedy trial rights, it did that based on a national emergency. Court orders were issued. I am not saying whether I agree or disagree with that, but that's something that happened. And I think one of the cases the state cited in its response brief, State versus Ish, I think that particular case had 422 days of time between when the remediator was issued and when the case went to trial. And that person asserted their speedy trial rights that whole time. That happened during COVID when the court had its emergency orders during that whole time. So I think to say, well, it's a capital case and they're a lot different than they used to be, and they are, and they're a lot of work and they take a lot of time and investment. They do.
Right.
But there's nothing that's been changed in our Constitution, in a court rule, in a statute to say if it's a capital case, speedy trial, really, you just don't have that right. A person facing the death
Well, you
penalty just
can't.
doesn't have that right.
You can't get rid of that right.
All of those rights exist. They all exist right now.
And rights
And
conflict.
Mr. Kohberger had to choose
Right.
between those rights.
Yep.
And I
And
think the court can and should strike the death penalty in this case based on the
Well,
record
that would
here.
result in the death penalty being struck in every case.
Your Honor, if that's the way it is.
She's like, "Fine with me."
Because our clients collectively in the state of Idaho, when you have a capital client, if that's the case, then that's the case. I mean, we have been doing
The
this.
Constitution is flexible enough for the Supreme Court to itself say, well, we can pause that right. And we can expand that right based upon the circumstances, i.e. COVID.
but he
Why
waived it
can't
here.
expand the time that speedy is measured by constitutionally, given that evolving standards have required more time to present a capital case and measure it against that.
She is
I
again
would say.
making an argument that applies to this case, but also doesn't. This is a larger policy issue of, Your Honor, the standards required for effective assistance of counsel directly conflict with the speedy trial right. And because those two things conflict so strongly, then a defendant is being denied their constitutional rights, and therefore the remedy is to strike this as a penalty. I don't think the court's going to follow that chain, but this is a larger, again, policy conversation that applies to this case, but also applies more broadly. And they're going to keep bringing the arguments because then it preserves the right on appeal. And then if there's a conviction, they can continue this up the chain of courts within the state to have these evaluated. So she is preserving her record to continue to make these arguments forward because they have to argue them now and then continue to argue them differently or up the chain of courts.
That I don't know whether they can or they can't, but they have not. And that's the critical area. I would say the Supreme Court probably would believe it could do that, but it has not done it. And I would say they would believe that they could because they did so during COVID. But that hasn't happened. That has not happened.
So you think that the Supreme Court would likely say, well, as opposed to interpreting the constitutional right more broadly to apply over the more flexible, given how the defense of capital cases have evolved, they would be more likely to say, well, we're just going to not have any capital cases, period.
I don't know if they'd say that or not.
Well, that's what
But
you're asking me to say.
I'm asking you to say that. I'm asking you to
My
do
job as a
what,
district judge, if there's not an issue that has been decided by the court, is determine how that court would decide things.
well, I think you can consider what Judge Boyce did in the Vallow case. And
That's what
that
she's
had
asking
to
for.
do with
Everyone in the chat
discovery
everyone in the chat that said, hey, is she relying on what happened in Vallow? Yes, she has expressly stated it, but yes, that is why. That is why. All of you in the chat were like, she's relying on this. Yes.
counsel didn't have enough time to review and to prepare for, and it would
That
have
was a discovery
disadvantaged the
violation, though.
client. And so Judge Boyce in that case struck the death penalty.
That was as a result of the state having failed to provide the information, violating its court order. And then the remedies were, well, do we push trial back or not? And
that
the
wasn't the
choice that Judge
defense's
Boyce
fault.
gave the defendant was, well, we can go to trial, but I'll remove the death penalty because a lot of the discovery related to that. Or we can
It was a remedy.
continue the trial for you to review that. But so you can either go to trial with the death penalty, without the death penalty now, or you can expand it with the death penalty. One defendant chose one and the other defendant chose the other. But in this case, the decision to waive Speedy was not as a result of, as I understand it, a violation of a court order by the state.
It was as a result of a court order. And when we waived Speedy, we advised the court and counsel that this motion this day was coming. We don't think it's appropriate to force somebody to choose between competing constitutional rights. Lori Vallow had not ever waived Speedy trial. And so she had the choice to waive Speedy or not face the death penalty. And we think that since we were forced to choose between rights, those should be reinstated and the court should strike the death penalty.
Thank you.
And the court is saying, no, that was a remedy. Like in the Baldwin case. Look, we saw this in Baldwin too, right? Baldwin's attorneys argued for the Brady violation, and the court, as a remedy to that violation, said the state's egregious fuckery summary is what is warranting this remedy. In Vallow, the court is saying, right, the state didn't turn over evidence in violation of a court order, and that evidence largely went to the penalty, so the defendant's got a choice. It's a remedy. Here, it's not a remedy to something. It is a choice, which is what we saw the court do in Baldwin vis-a-vis Hannah Gutierrez. The court is saying, right, just because Baldwin got this remedy doesn't mean you are similarly situated. These cases are very different. And Ann Taylor is like, yes, but we'd like you to do that here. And the court's like, nah, nope, not the same, not the same, not the same. I think she just said, Mr. Longston, I'm glad you made it.
Thank you, Your Honor. So not only can the Idaho Supreme Court do that, it's already done it. The Idaho Supreme Court has said that we interpret Idaho's Constitution for speedy trial the same way that the federal Constitution is interpreted under Barker. There's one exception that has no application here. And so it's an individualized test based on 4 factors, and you're really looking at kind of the overall reasonableness of the delay. I would direct the court specifically to the Langford case that just came out last year. The Idaho Supreme Court walked through the difference between the 2 constitutions, explained how they operate, and then found specifically in that case that they charted out how many delays there were, what the delay was for, who caused the delay, and then was it reasonable or not. And they found, they said, in sum, most of the delays here were precipitated by Langford's own actions. In the case of the last and longest continuance, the delay was reasonably necessary to allow new prosecutors and new defense counsel time to prepare for trial. So they found that's a reasonable, under the Constitution, that is a reasonable delay.
Different here.
So there is no choice here. You don't have to choose between speedy trial or effective assistance of counsel. You can have both. I think what the defense is saying is they've lost their statutory right to 6 months, which they do lose if they take an action to delay the trial at all. But that's not a constitutional problem that they have to give that up if they want to maintain their constitutional right to effective assistance of counsel. Now, in this case.
Well, and that was my point in perhaps not well stated, is that it seems what this defense is trying to do, and perhaps you can comment on whether I'm saying this correctly, is to engraft what was the territorial law, which is that a case had to go to trial within the, at that time, courts were held in sessions, calendar sessions, right? I think there were 2 sessions a year or something like that.
Which is
was
very
Speedy,
different.
right? And then we had the Constitution that doesn't, necessarily give us such a fixed time frame. But the argument is, well, because that was the territorial law at the time, therefore that's the constitutional right, and it is engrafting that statutory construct to mean the constitutional right.
Potentially, Your Honor, though I'm not sure that's exactly, because my understanding of the pre-Constitution statute was that it was based on kind of the circuits and when they came, and we don't do that anymore. And so that time frame just doesn't make sense today. You wouldn't be able to just engraft that in the Constitution and apply it today, because
my point is that's, I think, what this defense is arguing, essentially.
Yes.
Yes, Your Honor, but the statutory right they're pointing to comes from the new statute that was passed in 1980 that gives the 6-month time period. And regardless of whether they want,
Argument that the 6-month is functionally equivalent of the twice a year circuit.
Well,
if that is the argument,
6 months would be twice.
I don't think that it gets past the Idaho Supreme Court has said, no, it's not. So, under the Idaho Constitution, we use the Barker test. The crux of the matter here is that the defendant didn't have to waive his constitutional right to a speedy trial. He did. He did so under advice. He did so in writing. He did so
had
knowingly,
counsel.
but he didn't have to. The trial could have been continued, even at his own request, without him waiving that right. He waives it statutorily by moving for a continuance or to ask for more time to prepare, but he does not waive it constitutionally. If he did, then most of this Langford analysis would have been completely unnecessary. But instead, at the end of the day, when you do finally get to trial, the reviewing court looks back and breaks out segments of time and says, whose fault was that delay? And as the court said in Langford, many of the delays were because of Langford, and so they don't count against the state. But the court easily could have said, well, he asked for a delay, so his constitutional right was waived. They didn't, because that's not how it operates. So the real problem here, I think that the defense is grasping with, is that they didn't need to waive his constitutional right, but they did. So, there's not much the state can say other than that wasn't required.
I don't think
The
that's exactly
Constitution
what
not
they're
only
saying.
can be flexible, the Idaho Supreme Court has held that it is in fact flexible. And
I appreciate the state's framing, but I think what the defense is saying is you either go to trial within the period or your attorneys are prepared, and that's not a choice someone should have to make in a case where so much is on the line. And in a case where so much is on the line, how do you balance those rights? And we've still been fighting over discovery. So really that's more the state's fault. And the court, when she was bringing that up, said, but there's been no court orders that have been violated. So the beeping is my weather radio. I don't know why it beeped. So we're going to continue on.
the reasonable, a proper reason for delay is to prepare for trial. And that means this is not a choice that has to be made by any defendant. It didn't have to be made by this defendant, but he chose
But
to.
it was made.
Unless there are any further questions.
The defense feels like it had to be made. That's how the defense is arguing that it was necessary.
We're not trying to graft in a time into the Idaho Constitution. We're looking at the
the
word, the
statute says
guarantee
6
for a
months.
speedy trial and trying to figure out what the word speedy means. And so
Well,
the
isn't
statute
speedy
says
mean
6
the
months.
Barker test?
at the time the Constitution was written, I don't think it did.
But isn't that what the Supreme Court has said it means?
I think our Supreme Court does agree that it's the Barker
Again,
test.
I think I probably can dispose of a number of motions by simply saying that the defense asks me to do X. Doing X would violate the binding precedent of the court. Denied.
I think if I was here saying dismiss the case based on a speedy trial violation, I think that's exactly what the court would do. This is a little bit different. We're asking for the court to set the case back to the point where we had to choose between constitutional rights and to strike the death penalty.
You could also
In our case, this is the
do
last point I'll make.
interlocutory appeal, right?
In our case, we signed a waiver of speedy trial, and it was a form, I believe, that was generated by the court. It was signed on August 23rd, 2023. Mr. Kohberger signed it, and I assigned, with the parentheses, attorney for the defendant. And in that form, and remember, our scheduling order said you have to do it by this day, or you don't get a continuance, you're just going to trial.
Couldn't you have
We
appealed
gave up
that then?
The right to, under the United States Constitution and the Idaho Constitution. And I have a printed copy, but I know the court probably has the entire court file. That's it.
All right. That, along with the other motions,
Submission.
will be taken under advisement. Let's take a lunch break. It's 5 to 12. Adjourn at 1 o'clock.
All right. The court is taking a lunch
All
for
right.
about another 20 minutes. So we will also take a lunch. Well, it's going to be briefer than that, but the court should be back about 20 minutes from now. I'm not going to go to break yet. I'm going to answer some questions and then we'll go to break. But the court, let me get caught up in real time here. Make sure that we are caught up in real time. There we go. But the court is taking their lunch break. We have, let's see. We have 2 motions left. The court, I think, was anticipating that some of those motions would take long. Well, the motion to strike based on speedy trial is like a part 1 of 3. And then there's 2 additional motions to that. So they are taking lunch. There are numerous motions left. And we will be taking a lunch break as well. Miguelina, let me know if that would impact the stream that we have set up, and if we need to switch to a second one, just let me know. I'm going to answer a few questions. I'm going to grab something to eat real quick and then come back. So we will probably only be on break for about 10 minutes. So we will make sure to hydrate. We will make sure to do all of the things, and that's what we will do. Kelly said, so is this live? Yes. Why does the court feed say November 6th? I have no idea. Somebody might have titled it wrong. This is live today, and I don't see the court feed saying November. Oh, that's our feed. That was our typo. We're pulling this from the court's feed today. So I also see in the chat that Maritel said, can we please explain the Lori connection? There is not a connection. The defense is arguing, you did this in this case, we should do this here. So the defense is arguing what happened in one case should happen here. They are the same jurisdiction. They are the same location. And that is why it's like, well, the judge in this case did this. So can't we do that? And this court is like, I don't know if I'm going to want to do that. So that is why. I'm going to take just a few more questions and then we'll take a break. NR, there is not. You can head to lawnerdlounge.com. We can put a link in because the Law Nerd Lounge is where all of that lives, in the Law Nerd Lounge. So let's do a couple of our questions from Super Chats. Take a quick break to hydrate. I'm going to grab, I will probably be eating while streaming, but I want to at least get up, A, move, B, hydrate, C, use the restroom. And don't worry, we'll put on our shorter hold music today, so it's not a problem. Let's see. Chelsea said the state dropped felony murder 2 weeks ago. Thank you. We're down to HAC, utter disgust, multiple victims, and future dangerousness. Chelsea, I appreciate it. Thank you. When the court broke all these down, I was going off of the court's list. So when I was prepping, I was going off of the court's list. So I appreciate it. Mike said, thank you so much for being my comfort stream. Mike, we're here for you. Thank you for being you. You are welcome. You always brighten my day. You guys brighten my day too. So thank you, Mike, and much love back at you. You guys always brighten my day. I'm happy to be here talking about, all of these things, all of the court things. And we're looking at the blending of how courts interpret laws, how laws change, how laws get written, how laws get implemented, how they get argued over. And that is what we do in courts before trial all of the time. That's a part of an attorney's job, is to argue, this might be the way, but should it be? We saw that with Alan Jackson, right? The judge is like, this is how we do it in Massachusetts. He's like, yeah, but you sure about that? Like, maybe that shouldn't be the way things are done. Maybe it's time for the way things are done to not be done that way. But things do not shift and change and evolve until there are conversations. And in law, it's lots and lots and lots and lots of conversations. So that. Laura said Ingrid Beatty from the AG's Office of Law and Attorney for the state was also assigned to Chad Daybell's trial. She's phenomenal, intelligent, and emphatic, complex case expert. She's been great. I did the whole outfit. No, she's been great. And I'm not surprised that they brought in, it depends on the jurisdiction where you are. Not all DA's offices are large enough to have people who specialize in DP cases in additional specializing in other things. I worked in a very large jurisdiction, so there were people who specialized in just about everything you could imagine because we just had such high volume cases. If you had a very nuanced issue, somebody has probably addressed it before. That's not the same in smaller jurisdictions that don't have as high volume. The more cases you see, the more issues that come up. It's like, you know, the more games you play, the more you refine how you play the game because you see more scenarios. Not to compare court to sport too much, but sometimes the analogies are appropriate. Let's see. Kristen, thank you so much. Kristen said, I appreciate you in this community. I appreciate this community and all of you. Panto Fool, I think I pronounced that right, said this is fascinating. Emily, do you believe in the DP? Well, I don't know if my thoughts, opinions matter that much because each state gets to decide for themselves. And so each state gets to decide that for themselves. I have not looked since law school at updated information about whether it even works as a deterrent. I think there is much room for conversation about where the balance between deterrence, rehabilitation, and punitive measures balance. I also don't think that it's for me to decide in state by state. I also thought that with my cases that I personally handled, I very much wanted to have input from the victims' families. And that was something for me that was always very important to hear from. How do the victims' families feel about a given thing going forward? And sometimes victims' families have very strong feelings one way or the other. And I think that's something that prosecutors' offices should always take into account. But again, it's something that states get to decide for themselves. And I, again, have not looked deeply into it really since law school. So that's where my thoughts are on that, is that I think that states should get to decide for themselves and their offices. Well, you can see Ann Taylor is very much arguing that in this state, this is not working and this is not what we should be doing. You didn't hear the prosecutors argue in this state, this isn't working, or this is working, this is what we should be doing. The prosecutor's very measured argument is, this is what the law of the state is, and we apply the law of the state. And so I think I kind of fall where a lot of prosecutors fall, which is, this is the law of the state. And if the state wants that law, it's the job of the judge and the prosecution to follow the law. And so a lot of how I approach cases is based on the law says this, we should follow the law. And if there's room for the law to change, then there should be advocacy for the law to change. So if that's very much how I see the role. I don't know if that makes sense, but I hope that makes sense. Let's see. When juries have been on a case for a long time, like the YSL case, are they expected to go a year plus without a paycheck? Brittany, it depends on each juror's situation. States do not pay enough for jurors at all, but most jurors should still be working. And when they qualify jurors for hardships, employers cannot fire a juror for being on jury duty. So they should still be getting paid. They will hardship out people who will not make any money during the time that they are on jury duty. So it's part of the hardship consideration. And yeah, they're not at work, but in especially like the YSL case, there have been weeks-long breaks, months-long breaks. So those jurors would be on jury duty and then would go to work for 3 weeks and then be back on jury duty and then go back to work and back and forth. So they are not expected to do that, but financial hardship becomes a consideration for courts when cases are more than a couple days. If you come into a judge that's like, this is going to be a 4-day case and you're like, I have a financial hardship, the judge is like, okay. But if it's a case that's going to be months and months and months long, it's something that the court very much accounts for, because you can't have jurors that are distracted by the fact that their lives are being negatively impacted, or they can't care for children, family members, or whomever. You can't have jurors distracted by the things going on in their life to the point that they can't be fair and listen to the evidence. You don't want jurors who are like, can we just be fucking done with this, please? You need jurors who are in a position where they can sit and pay attention because their life circumstances are not overwhelming. Hopefully that makes sense. Let's see. Slushy Slush Fund said maybe BK's pushing for a fast trial again. I think it's more of pushing to get things stricken and trying to figure out the best way to argue that, and then preserving those arguments for the future. It is very much something on defense attorneys' minds to preserve arguments for the future and make sure that they can argue it next step. And that is in this case, I would imagine they know exactly what they're trying to preserve going forward, because that's what they do in these cases, and they're used to these cases. Tosh Bidez said, oh my God, your hair's so cute. Hey, ADB, can you wish my bestie and fellow law nerd, Natalie, a very happy birthday from me, from Tasha, me being Tasha and me being me. So bestie, Natalie, happy birthday from me and the law nerds, and from your BFF, Tasha. Yes, we can. Megan said, thank you for your breakdown, EDB. I'm less confused because we didn't cover all of these motions, and there's a ton of them. I understand we're jumping in kind of cold to arguments. Everyone else has read everything that's been filed in court. We've jumped into the arguments a little bit cold, which is why I've tried to break down what they're arguing as we go. But yes, it feels a little bit like, wait, what? Which is why sometimes it can be easier to follow after trial, right? It wasn't hard, I don't think, for anyone that watched the Karen Reed case or watched what happened immediately after the Karen Reed case to follow what was being argued and asked by the courts, because we're so in it with that case. It becomes a little easier. This is missing a little bit of context in this case. Kathy at Oz said, happy birthday to me. Kathy at Oz, happy birthday to you. I know I saw the law nerds wishing you happy birthday, but I wanted to pull it up and wish you a happy birthday on the official stream record, as well as in the official chat of the stream. Chat, we've got about 10 minutes before the court's back. I'm going to very quickly grab some water, so I will be back in less than 10 minutes. Court will be back in less than 10 minutes. I'm going to put on some of our music. Let's see. What are we vibing with today? Maybe? No, not that one. No, not that one. I'm like, this one. Look, we need a little upbeat. We'll leave this one. I will be back in less than 10 minutes. And the court is on break, so I'm going to give you our quick court is on break video, and we will BRB. Chat, appreciate you. See you soon. Hello, law nerds. All right. We are going to head back to court. So thank you guys for being here. Court was back just a few minutes late, and we're not going to have much Zoom room. I hope we are going to start. Wrapping up, but we will see. We will see. So they are just coming back now, and we are going to join them as they are coming back. And if we end up with Zoom room, we're going to 1.25 so that when they're done, we're done. Because, you know, today we have things to do. Also, I'll put my hair down now that my in-ears are in, because it's hard to put them in without getting hair stuck in my in-ears. You know, long hair problems, or long enough hair problems. So unbound hair problems.
All right, we are reconvened in the matter of State versus Kohberger.
You're back.
Defendant is present together with counsel. I would note for the
Mr.
record,
Longston
Mr. Longston is present as
joined
well.
us.
At this point, the state is present through its attorneys.
Gang's all here, says the court. We have like 2.5.
I think next we started
left.
Those categories that I had identified as the 9th topic. We'll continue with those and then circle back to the 8th. So let's
course,
talk
like-
about the state's concern about the
Speedy. No, we
grand
didn't.
jury not having considered the aggravating factors.
The defense didn't argue on that yet.
Next.
So the defense is now going to argue about the
Logston.
grand jury not considering aggregating
Apologize for not
factors.
being able to be here earlier for proceedings, Judge. I overbooked myself today.
You're here, so that's fine.
You're asked to the
He's like,
argument as to including the statutory eligibility requirements for a death case in the grand jury. I think the two major hurdles that we have to get over are, one, the Hurtado case not requiring the grand jury to apply to the states. And then the second is the ruling in Abdullah that essentially said you don't need to provide these to the grand jury.
Seemed like a good place to start.
The defense is acknowledged. Your Honor, there are two hurdles we have to overcome. And those hurdles are case law directly on point that says that the grand jury does not have to be presented with aggravating factors. So the court's like, yeah, that's a good place to start with the fact that the law says the opposite of what you're asking.
Start.
It is a good place to start. And as we tend to do in these cases, because they are going to go up on appeal, we are, of course, asking that
If,
those things be overruled. Certainly recognize your Honor doesn't have the
did you see the
ability
court
to do that.
almost roll his eyes?
But we respectfully make the argument that those cases were wrong. We also make the argument that there is another way to get there. So the Fifth Amendment obviously is the grand jury amendment, and I think Abdullah was looking at the Sixth Amendment or notice requirements and what needed to be included there. We furnish an additional argument that the Eighth Amendment in death cases requires additional process. And we see that largely in what occurs at the sentencing hearing, but we also see it in things like requiring counsel before it was required for anything else was required in death cases. We also see it in requiring the state of Alabama to permit a lesser included instruction so that a jury can choose something besides something that would lead to
Let me
death.
ask you a
And they don't
question.
have to.
So on the one
present that.
hand, as I understand your argument, it is that the grand jury should be required to not only find an aggravating, statutory aggravating factor, but also that the grand jury then weigh it against mitigating evidence. Is that your?
No,
your
that can't be
position?
their argument.
No. Let me be clear. As we would talk about in the trifurcation motion, I'm only talking about the statutory aggravators, not the non-statutory aggravators or the mitigators. It would simply be.
Your brief says otherwise. So that's why I question that, because as we've learned, that takes a long time for those things to be
Develop.
developed. That's not necessarily evidence in the pocket of the state. What is now gone from a case timeline of several months to now multiple years would seem to me to even drag it out longer.
And I certainly understand that concern. I don't think that that's our position. I certainly do believe that the law would require the state to put on mitigating evidence if it had it, because that's something that they're required to do by law. They're required to put on evidence if known
But
to them
not
would
evidence,
possibly.
but not, no. The state is required to put on mitigation against probable cause, but the state's not obligated to put on mitigation against an aggravating factor to seek that this be a capital case. Those are two very different things.
Point in the direction that the person is innocent, et cetera. But I don't think what our position is that the state would be required to put on essentially their entire sentencing hearing in front of that grand jury.
Right.
The grand jury is still only just determining whether or
Probable
not
cause.
there is a reason to go forward with the case. Our point is that at the time of the founding, that grand jury would have known
If you
that
said Magna
all
Carta.
felonies lead to the gallows. So at that time, grand juries were making decisions about whether or not people were going to face the death penalty. And it wasn't until the Supreme Court after Furman in the 70s that we came up with this entirely new system. But it's one where the grand jury has lost its part of its function, where it's looking at whether or not these people should be facing the death penalty.
But it's
Essentially, they were deprived of that through the transition that was obviously intended to protect people from an arbitrary infliction of the death penalty. But the grand jury itself is supposed to also have a role in that. It's supposed to protect people from arbitrary decisions. And so that's essentially what our argument is that there should be a neutral fact finder placed between the citizen and the state when we're making the decision whether or not the death penalty should be sought. And so that is one of the reasons we're asking the court to strike
not the law of the
death
land
penalty in
today.
this case. Does the court have any other questions for me?
Smart
Judge.
argument. He's like, we know what we're asking for does not comport with the law today, but we'd like to preserve
Your
this
Honor,
argument to argue to the
sounds
appeals
like on
court that it
Abdullah,
should
this is
be.
just a issue of issue preservation, so not much to comment
Correct.
on that.
Correct.
In terms of this other argument that they are saying you can look at it differently through the Eighth Amendment, keep in mind the Eighth Amendment is just the prohibition on cruel and unusual punishment. It's quite a stretch to jump from there to requirements on what needs to be presented to a grand jury. The Beck case that they cited suggests that maybe there could be a connection if that diminishes the reliability of the sentencing determination or the guilt determination, but that's not the function the grand jury plays. And so for this court to stretch the Eighth Amendment all the way back to the grand jury would be.
In fact, with respect to failings of a grand jury to pass on a particular element, for example, if there's been a trial, the general standard on appeal is, well, the matter went to a jury and they made the determination there's proof beyond a reasonable doubt, and therefore any error is moot.
Correct, Your Honor. And I think really that gets to the heart of this claim, which is it's just kind of another way of their argument that it shouldn't be the prosecutor deciding that a notice is filed. And the U.S. Supreme Court has said it's not a problem if the prosecutor has unfettered discretion in who gets the death notice and who doesn't. So that by itself isn't a problem. So unless there are any other questions.
He's like, we're going to go sit down. This is an issue preservation argument.
Any rebuttal?
Has it been preserved? Has it not been preserved?
Well, I think it would be best to push back at least a little on the idea that the Eighth Amendment can't go back that far. I mean, recall that it was the Eighth Amendment that required that there be counsel for people that were facing the death penalty. Now, I certainly understand the idea that the Eighth Amendment's concern is that we have a reliable procedure. I certainly understand that. But the grand jury, it does fulfill some of that function as well. And besides, at least if we're speaking in terms of what was understood to have a grand jury and what it did at the time that the nation was founded, it would have been
So
stepping
close.
in a
So
case
we're getting so close.
involving a possible death penalty and being able to put a stop to it then and there. And so I do think that the Eighth Amendment has the ability to attach even that early on, at least in cases involving death. And then I recognize that there are these cases from the Supreme Court indicating that prosecutors do not have to have anybody determine whether or not they can file the death penalty and that they can drop it out of a sense of mercy. I think that's a slightly side question to if they choose to go forward with it, who
I
can
thought for a
stand up
second he
and
was going to say side quest.
before we spend years
Honestly.
on one of these cases, that this is not the appropriate case. Someone besides the prosecutor, which is what we have with grand juries and preliminary hearings, et cetera. And so we still believe that the argument here is one that can be passed on by this court and that hasn't necessarily been ruled on by these other cases that we also think should be overturned. Thank you, Judge.
Thank you.
He very much appreciated the fact that
I
he was.
believe I have all the remaining arguments, so whichever the court would like to.
Where would you like to go next, Your Honor? He very much appreciates that he is asking the court for something that they are disinclined to do to preserve the issue for appeal, and has made the arguments he needs to make and then moving on. He knows what's going to happen. He knows what the court is going to do, but he's also preserving it so you can actually argue it another day. If you don't preserve it, you don't get to argue it later. Use it or lose it. So now he's got the rest of the arguments. So we're going to hear at some point, we might get not just to the founding of the country, but also back to the Magna Carta. We'll see. Field codes will probably come up because that is the area of study that this attorney seems to focus on quite a bit.
Your contention that the death penalty should be struck because it violates international law.
Thank you, Your Honor. So that motion is largely premised on the International Convent of, I'm gonna have to pull it up because it's the ICCPR.
The court's like, mm-hmm. Mm-hmm. Do we have any Zoom room?
And so essentially
we have a scintilla of Zoom room.
the argument comes down to this. We have signed and ratified a treaty that would put, we think, additional requirements on what we would do if we're going to have a death penalty in this country, and then obviously we have one. One of those is a requirement that we make sure that we're not arbitrarily killing people. And the other one is that people are not being essentially tortured.
My understanding is when the time that that convention was ratified with the understanding that to the extent that it is agreeing to anything, it is agreeing to afford the Eighth Amendment protections.
Right, which exists.
That's correct, Judge. And I think to some extent,
So the Eighth Amendment
what we're arguing
applies.
is
Cool.
the Eighth Amendment and the ICCPR work together, and that we can look at these international obligations and the Eighth Amendment and say that for them, they essentially are the same thing. That's why we talk
Well,
about.
if they're the same, then the
Well,
Eighth
I think
Amendment
there's-
applies. and
You're
you
looking at
made
from
those
two different
arguments.
prisms. I think what the state is saying, to the extent that this covenant applies, which, is a question about whether it's self-executing and all the rest, it only governs to the extent that the Eighth Amendment, apart from that, would have protected that situation. Whereas what I think you're arguing is that the Eighth Amendment must be read to be broader as to what international law would
That's not
dictate.
gonna- that's not gonna-
I think if what we're saying is that the state would argue that we read the Eighth Amendment and that's what the international law must be, we're saying you have to read the international law to decide what the Eighth Amendment.
Right.
So you're having
You're
international
asking to
law
expand
dictate
it.
what the United States Constitution means.
That's what he's
Correct.
asking for, correct?
And we are doing that on the basis of what the United States has said itself about the fact that they believe that they live up to these things, and the fact that we have, we discussed the charming Betsy canon, which is obviously a very old canon and typically is just about whether or not our statutes are in line with our treaties. But I think particularly in this case, where the United States has essentially said, we signed on to this treaty because we live up by these same standards that everyone else does. We can look at what the international community thinks about those standards that we said we also abide by when we're determining whether or not we're living up to the standards in the Constitution.
But what they said specifically is that we think that we are living up to those, even though we have and will enforce a death penalty.
And I think, which is why we're not saying necessarily that the death
It's a
penalty
very fine
would be
needle to
struck
thread, sir.
if it was done properly. Our argument is that the way that Idaho has its scheme set up, there are far too many statutory aggravators. And some of them are just big enough to drive a Mack truck through.
And this is what they were
So just about
arguing
every
earlier.
murder could be charged and have the death penalty attached to it. And so that doesn't require the narrowing that we've said we're going to provide. And it certainly doesn't live up to what the international community would expect from us.
Yeah, I understand
Okay.
the argument.
Well,
Like the court's like,
Falling
yeah,
off,
no,
I'll
I
be
get
frank,
it.
It's falling about as flat as you would expect it to fall before our Supreme Court or the Supreme Court of the United States.
well, you're all right. It's an argument and it must be made. So
This judge is just like, have you preserved your record, counsel? Have you preserved the record, counsel? Because we're flat Stanley level falling flat, sir. Oh my. This judge brings the sass. Just, and again, counsel knows. He's not surprised this is the response. He's like, it's an argument that we are making.
provide, and it certainly doesn't live up to what the international community would expect from us.
Yeah, I understand the argument.
Well,
Falling, I'll be frank, it's falling about as flat as you would expect it to fall before our Supreme Court or the Supreme Court of the United States.
well, you're all right. It's an argument and it must be made. So
You need to make a record.
The court's like, but must it though? The state would be like, would the court like me to add anything?
Your Honor, unless the court has any questions, I'm okay.
I don't, thank you. All right, let's talk about the
Moving on.
contemporary standards of decency.
That's going to be denied.
thank you, Your Honor. So
He's like, thanks, Your Honor. Let's
I
try
think
this
the
again.
main case for this one was Roper v. Simmons. Unless I'm confusing it with Atkins, but essentially the court has said that when deciding what contemporary standards are in terms of
So
what's
we're moving
cruel
on to
and
the next
unusual,
motion to strike.
that the court first looks at what the state legislatures are doing and then makes a decision based on its own determination of what it is it's going to be. But when we look at those cases, they also look at other things. They look at international law. They look at what religious organizations are saying.
I wouldn't bring up international law
They're
again,
obviously
sir.
looking for what's the consensus going on.
I think Idaho Supreme Court said is what we look at is legislative and governmental determinations and actions.
That I think I think that's Abdullah where they had said that. And I think that was partly because the way that it was.
The court's like, right, but I have to follow what the law says. So I'm going to do that.
And in those cases, it seemed like the record that was brought up to them was somewhat sparse. And so hopefully we've provided more information than they had at those times.
No,
But in
we've done
those
it better.
cases, the number of states that still allowed the death penalty, I think, was around 35. And as the court, as we noted, that number has dropped somewhat precipitously since that time.
And those would be the legislative activities. I think what I was, I guess, taking issue with is the idea that they would look to what religious and other sort of non-governmental advocacy groups
There's like a
would,
separation
argue or
of-
accept.
Church, state, all of that.
Well, I can only say that Roper definitely looked
He's like,
at
sir, the legislature, can we just, you've made your point. You've preserved it. Let us continue.
international law. And if it wasn't Roper, then it was Atkins. But the one about children and whether or not they can face the death penalty, they definitely looked to international law. And so
But there's also
I don't think
case
there's
law
anything
and
that says that the court
statutes on
can't
that.
look at whether or not organizations have moved against the death penalty. We are becoming somewhat alone in the world in terms of continuing to make use of the practice. The number of states that are still doing it is shrinking. And so when you look at that total fabric, it's our contention that we've reached the point where the death penalty really ought to be abolished. And so that is our contention in this case.
And there's a
you, Judge.
procedure to do that. This is just not that procedure. There's procedure for these, there's places for these conversations. This is just wrong
Honor.
audience.
While Roper may have looked at some international law, I think the Idaho Supreme Court has really narrowed that window. First in Abdullah, they said, therefore, absent some legislative or executive action, a determination by this court that Idaho's death penalty statute is unconstitutional based on evolving standards of decency and public opinion is unsupported. So they're really looking in at that. And fast forward 5 years in the Hurston decision, 2020, the Idaho Supreme Court reaffirmed that view and then also said, quote, we continue to subscribe to the view of legislative bodies as the basis for determining a national consensus. And so, and the reason for that, they explain in Abdullah, is that courts just aren't good at taking a temperature of public opinion and what represents society's views. Now, looking at the states that have capital punishment, according to the resources both sides have cited, there's 27 states that still have it on the books. That's a majority. They've pointed out that there's gubernatorial moratoriums in 6 of those, which is true. But that means worst case scenario, there's 21 states that still have the death penalty on the books and can use it. And what the Idaho Supreme Court said in Hurston is that we're looking for a national consensus. And we're nowhere near a national consensus that the death penalty is somehow immoral or improper or indecent. I would also just note, it's not enough if what you're trying to show is a national consensus. It is not enough to just point to the fact that a state doesn't have the death penalty. You would have to show that the state removed the death penalty because that state believed that it was immoral or improper. So for example, if a fiscally conservative legislature just decides they don't want to fund the death penalty, but they have no moral objection to it, that's not evidence that there's some societal standard that would.
What do you take of evidence from a state who
These are
is not
arguments
enforcing the
for
penalty because, for
legislature.
example, an executive of that state is morally opposed to it and has the power to preclude it from being applied? Should that be considered?
So the Idaho Supreme Court did mention executive action, although in Hurston, they seem to say the better picture is painted by legislative bodies. And I think part of the reason for that is because the executive, it can just depend on the administration that's in power at that moment. A perfect example of that is the United States. The death penalty is on the books. It's currently not being applied, but shortly before the current administration, it was. And I think it's safe to assume that it will be again here shortly. The other thing you have to look at is, why is the executive doing this? For example, the defense cites that Tennessee has currently a moratorium. True, but the governor did that because he said we need to take time to fix the execution protocol. That's not evidence of a national standard that the death penalty is wrong.
So in a state like Tennessee, are they still
Can we be excluded?
sentencing capital sentences, but just not carrying them out, or have they stopped even trying?
I can't answer that
cases?
question. I have no
I
idea.
can't answer that definitively for Tennessee. My understanding is that they still try them and impose the death
I
sentence,
truly
but
do
that
not
it's
know.
just not being carried out. I know that to be true, for example, in California, juries
That
are still
I'm
imposing the death
Much
penalty.
more familiar with.
I know in Ohio,
They're not
another
carrying
state that
them
they
out.
pointed to where there's a gubernatorial moratorium, there are
It's
30
on
scheduled
clause.
executions in that state. They keep getting pushed back, but the reason they're getting pushed back and the reason for the moratorium is they can't find chemicals to do lethal injection. Again, that's not evidence that there's some standard of decency that's keeping them from doing this. They just can't find the chemicals to do it. So I think,
Well, I mean, you could imply that the standards of decency as applied by the pharmaceutical companies who refuse to take part in it is some measure of that.
potentially yes, but I think, again, going back to the Idaho Supreme Court's decisions, we're looking specifically at executive and legislative action. And the fact that the legislature or governor is saying we would do this, but we can't get the chemicals, is actually evidence that they still support the death penalty. So I think no matter how you read the numbers, we're not at a place where there is a national consensus that the death penalty is indecent. And so we think the court should continue to follow what the Idaho Supreme Court said in both Abdullah and Hairston and reject their motion.
Right. The law is
Thank you, Your
clear.
Honor.
Follow the law. Let's keep going.
Rebuttal?
The law is clear.
Just briefly, Judge, I would caution the court trying to figure out why it is that a particular state either dropped the death penalty or imposed a gubernatorial
But you've kind of
moratorium. I mean, I think
asked.
that these things are complicated. That looks an awful lot like trying to figure out from legislative history why something occurred. Half the time, what you see in the questions doesn't necessarily tell you what the legislature had in mind when they finally voted. And so I think the first step, as the United States Supreme Court has set it out, is just to look at the numbers. And then after that, the courts can consider other things.
Or 2021, if you take into account moratoriums. How, I mean, certainly more than a third of the states, how does that represent a consensus?
I would argue that the consensus can also come from the trajectory. So the fact that so many states dropped the death penalty within the last 10 years,
Creative.
and that appears to be the direction that things are going, is something that the court can take into account. I also note a lot of these states that have death rows and don't have a moratorium still aren't actually executing anyone. And so the actual number of executions in the states that are actually executing anybody is less even than that. I think it's something like 13 jurisdictions that are actually doing executions. So anyway, for those reasons, Your Honor, we are asking that you strike the death penalty.
Thank you.
On to the
All right,
next.
I think that leaves us with your motion to trifurcate the proceedings and
Yep,
to apply the
last
rules
motion.
of evidence in the.
So this is the
penalty
defense's last motion.
Right. So Your Honor,
And again, these are being preserved for appeal. There are laws continue to change. Laws will continue to change. Sentences can be changed. We saw that in the Scott Peterson case decades after he was sentenced. So preserving everything and kind of trying to look down the future and saying, we brought this up, trying to preserve arguments for 5 years from now, 10 years from now, 15 years from now is not easy. But even though there are times I look at these motions and I'm like, sir, international treaties, you never know what might happen 5 years from now. So they are doing their best to make a record, preserve it for the record, and move forward and say, look, this is what we're seeing, so we're preserving it now in case down the road these become arguments that are well taken. The court is letting him know it's not well taken now. You've made your record. And I think he's doing a good job of balancing preserving it without taking up too much of the court's time so that the court leans into the arguments that are more likely to have consideration. So that's what is happening. In capital cases, there is a substantial amount of litigation. And what we are watching today is part of that substantial amount of litigation. There will be lots more, but the weight of these considerations is very high, and it is the highest punishment that the state can decide, or ask for from a jury, depending on the jurisdiction like this one. So it is moving forward and saying, look, I think also it doesn't hurt that they know that this case is being watched. They know it's being watched by people in Idaho. And there might be those living in Idaho going, you know what, that is a good point. Why are we doing this? So it lays groundwork also for the conversations to continue to happen outside of court while still being appropriate conversations to happen inside of court. Last motion.
I tried a case via
Yeah,
the
yes.
trifurcated method. It went smoothly, and we moved this court to do the same thing. If it's not trifurcated,
Which case was that?
that was Renfro.
Which one?
Renfro.
If it's not trifurcated, what happens at the in the penalty phase is the state would be putting on both statutory aggravators and non-statutory aggravators. I think the states argued that some of those things.
Isn't there a post-conviction proceeding in which it's alleged that that is ineffective assistance to allow the trifurcation because you make the jury decide about whether or not an aggravating factor is there in the absence of any mitigating evidence that might otherwise affect their decision?
I'm sure there is,
Oh, what?
but
Wait.
I can't say.
Wait, what? Wait, what? So the defense is arguing to not just bifurcate the case, which means guilt phase. Did the person accused, in this case Kohberger, do the thing that they're being accused of? Then the penalty phase. He's asking to split the penalty phase into two. And the court just said, isn't there room and case law that says allowing trifurcation can be ineffective assistance of counsel? And counsel was like, so the court is not going to allow you to bake in appellate issues at the start.
If it's not trifurcated,
Which case was that?
that was Renfro.
Which one?
Renfro. If it's not trifurcated, what happens at the in the penalty phase is the state would be putting on both statutory aggravators and non-statutory aggravators. I think the states argued that some of those things.
Isn't there a post-conviction proceeding in which it's alleged that that is ineffective assistance to allow the trifurcation because you make the jury decide about whether or not an aggravating factor is there in the absence of any mitigating evidence that might otherwise affect their decision?
I'm sure there is. But I can't say that I agree because from a jury's perspective, I mean, you have
That's
to
not
realize
gonna go far.
these guys, these are people who have been pulled in. They don't have legal training. And now you're asking them to make a bunch of different decisions at the same time. And as we pointed out,
People can't
I mean,
make
we can
decisions.
go back and forth about, what's the, if you don't trifurcate, you're going to put on the victim impact during the penalty phase with everything else, right? And so whether or not there's even a statutory aggravator is now going to be influenced by all of the things that are emotionally really powerful. And so, I mean, we can go back and forth about, who does that prejudice? At the end of the day, a trifurcated proceeding is just simpler for a jury to do their job. They have to be able to make a decision about statutory aggravators to even have a death penalty in a particular case. Being able to do that with just a standalone, do these things actually exist first before you start to get into the mitigating and aggravating? I mean, you can put on some mitigating depending on what the aggravator is at the aggravating portion of the case. You can talk about, future dangerousness and things like that, assuming that the court decides to let it in. But if you don't do it this way, what you risk is that a jury is going to be influenced by non-statutory aggravators, victim impact statements, and on those grounds, say yes to one of the statutory aggravators.
But wouldn't that be
And,
after?
You also are telling the jury, these things you have to find beyond reasonable doubt, but these things you don't, and do all of that at the same time. And I mean, the studies have shown that juries really want to get these things right, and they really want to follow the law, but oftentimes the instructions that they get aren't really that clear. And I think adding to their burden by cramming it all into one hearing, it's unnecessary. The court has the ability, I think under Rule of Evidence 106, to let them do the function that they're supposed to do with the statutory aggravators. And then that way they can make that decision. And if they don't find any, you don't even have to do the next part. But if they find one, then you open it up into the state's case in aggravation and the defense case in mitigation. In terms of using the rules of evidence, as we pointed out, a number of courts have said, confrontation clearly needs to be able to apply. You have discovery that needs to go out. Rules of evidence are helpful, and they're certainly helpful when you're talking about the statutory aggravators themselves. And that's an area where if you're trying to make a accurate determination of whether or not those things exist such that you can have the death penalty, the use of the rules of evidence is, I think, can be detrimental to both sides if you just kind of allow willy-nilly whatever to come in.
Willy-nilly rules of evidence?
So for the other reasons we put in the brief, Judge, we are asking the court to consider doing this as a trifurcated trial if it gets there.
It's interesting to me that and I understand because Idaho's aggravators are different than what than where I practiced. I didn't practice in Idaho. It's interesting because some jurisdictions you have to do the guilt phase with some of those aggravators. Like on the verdict form, it would be, do you find that the crimes were committed? If you find the crimes were committed, do you find that there were more than one victim, for instance? And so if the jury has already found that there were 4 separate murder charges, then it's pretty easy for the jury to say, and yes, we find, that there were multiple victims if that was the only aggravator. So it's interesting to see that they're saying, no, the jury's going to decide the charges, then decide the aggravators, but they're asking that not to happen not during the guilt phase, but also not during the penalty phase. They're asking for like a middle phase. Not all jurisdictions have it during the penalty phase. I haven't done a survey of jurisdictions, but some of those things happen during the guilt phase to decide if there even will be a penalty phase. Because if they found, in this case, it would be difficult based on the facts, but if they found, or the facts as we know them, if they found guilt on 4 victims, then it would be a very strange result if they didn't find that there was a multiple victim aggregator. So it's interesting to see them arguing to do the guilt phase, then the aggravators, then the rest of the penalty phase. So it doesn't say that that's how they do it in Idaho, though. It seems that all of the penalty phase happens together, including the aggravators.
And Your Honor, just to briefly address the point about the confrontation clause and the rules of evidence. The defendant has fairly acknowledged in his brief that the Idaho appellate courts have issued binding precedent that's contrary to their argument today. The state's not going to belabor that point.
Right.
I think the case law is clear and the state briefed that. As to trifurcation, the defense has yet to lay out what exactly this process would look like.
Yeah, what are they
and what I
asking
mean by
for?
that is, at what point it appears, although the defense has not explicitly stated this, that they would encourage this court to adopt a procedure where the state puts on all of its aggravating evidence for all of these statutory factors, and the jury then goes to deliberate on these factors without hearing any of the mitigating evidence. Now, this is very concerning, and particularly, the state briefed this. You take the propensity aggravator, where the jury's tasked with determining whether or not.
Right. And that's the thing with having an aggravator on something like propensity that's not just fact-based on, did somebody, like in California, there's a lying in wait, or did someone lie in wait, or did someone use, is someone out on bail? I don't know if that is still, but they're very much more fact-based, where some of these aggregators are more individual-based. But I think if the jury's finding guilt, they can also take a look at the way that the crime was committed. Was it exceptional? Did it manifest exceptional depravity? Were there multiple victims? Those types of things. Was it done in a way that was an utter disregard to human life? Those sorts of things are very fact-tied to what's presented in evidence. But when you start to look at the things that are very specific to a defendant, that can't be put forth during the guilt phase. So I understand where the balance is here, and also where maybe some of the problems are with that future dangerousness aggravator.
Not, the defendant's going to pose a continuing risk to send them back to deliberate without allowing them to hear evidence in mitigation, that's very concerning to the state about what that might do to,
An appeal.
for example, the appellate record. And I think
Yeah.
that that post-conviction proceeding in the Renfro case really highlights the concerns with this procedure that they're asking the court to adopt. As to the assertion that this is simply too confusing to the jurors, the court will instruct the jury on what the law is. And as we've argued on these other motions, the court can't just start with the assumption that jurors aren't going to follow the law,
Right.
that it's simply too concerning or too confusing for the jurors. The jurors will receive instructions. They are presumed to follow those instructions as a matter of law. And the court should assume that these jurors will do as they're instructed.
If the
And
instructions
unless the
are
court has
clear.
any questions for me.
I mean, just make
That's all I have.
the
Thank you, Your
instructions
Honor.
clear. So we should be almost done. This is our last motion.
Well, for the record, it really wasn't that confusing. We had.
Well, if it's not that
propensity
if it's not that confusing, why are you worried about confusion?
in that case, we put on evidence that pushed back against that at that point in the case. It's cleaner from the jury's perspective. It was cleaner from our perspective. I don't think we even argued about it. I think the state just went along with it. And I
Yeah,
thought
well,
it went
did you see
pretty
the
well.
state? The
Um,
state's like, who? Name them. The state's like, who is just like, cool. But that's also very fact specific because there were times in Sarah Boom where we saw the state going along with stuff and we were like, what? And then we got to the end of the case and at least I went, oh, okay. Well, now this all makes sense. So cases are incredibly fact specific. Also, the procedure of doing it this way is doing it all after a conviction, as opposed to having some of those circumstances found during the guilt phase is interesting to me. And he's like, it's not confusing.
I definitely
Well,
want to
then
push back on the idea that, we have a tendency to have these tautologies in the law where we say, well, the jury is great and they'll figure it all out. And so long as we tell them what to do, then
Clearly.
they've done what they were told.
Tell them what to do
And
clearly.
there are studies that show that's just not accurate. I mean, there's the jury project. You can read what it's like for people to go through these things. And when we're talking about whether or not somebody's going to be put to death, I think it's important that we, really think hard about how these people are going to make these decisions. If we're going to do a normal, just a penalty session,
These
I
jury
definitely
people.
think it's something that's going to require some additional instructions. I know the Supreme Court just recently updated a lot of the ICGs, which is great, something that I've been advocating for. But there are additional things that I think are going to have to be told to a jury so that they can understand how that would function. And if you trifurcate it, it's going to make it simpler for them to understand, okay,
Not
you've-
if the
you've
appellate
now
court
found this
doesn't like
person
it.
guilty. Now you're
Just
going to be
bakes in
determining whether
problems.
or not one of these statutory factors exists. This is what they are. This is how they're defined. You have to find this beyond a reasonable doubt. The state's
Some of that
going
should just
to do an
go-
opening statement and a closing.
Some of that should just go
They'll
into
put on
the
evidence as
guilt
to whether or not
phase.
these things exist. This defense is going to come in, question those things, put on their case why those statutory aggravators don't
three
exist.
trials.
You're going to make that determination. If you make that determination, then we get to a sentencing proceeding where the state's going to be able to put on any additional aggravators that it wants to put on, and the defense can then put on any other information that they have that's going to be in mitigation. It works.
So it's
and it
like, yeah,
worked,
no.
regardless of whether or not the SAPD doesn't agree with me. It's
No, she doesn't.
I'd ask the court to consider it. Certainly, if the court decides not to do it, we'll have lots more conversations about how best to do that.
It's an intriguing idea. The concern, of course, is the desire to do this case once and not twice.
I
And
understand.
there's a
Ding.
protocol that has been approved by the appellate bodies
Ding.
versus the one that you're proposing now. And so that's always in a trial judges who tend to be fairly risk averse.
Ding, ding.
Well, thank you.
Who says that trial judges tend to be risk averse? Me. They don't want to do anything different outside the norm. They don't want to do anything new, because when you're looking at months and months and months of trial and hundreds of thousands of dollars, if not millions, you do not want to do it more. Again, it's interesting to me, but the factors in California are much more fact specific and less defendant specific. So they come up during that first phase. Interesting. I wonder how many jurisdictions put it entirely after the guilt phase. So it's all decided together, because then the jury is trying to decide if there are in fact multiple victims beyond a reasonable doubt, but then also deciding if there's aggravation and mitigation all at one time. And he's saying, look, these are different thought processes, but then multiple victims should go with guilt. And then the future dangerousness maybe should go with the aggravation and mitigation, because it's more defendant specific. I now want to go read law review articles. Like, it'd be very interesting if you could you split them and put the aggravators that are fact specific with the fact part of the case and the ones that are defendant specific with the defendant part of the case? I don't know. That would be interesting. I am curious. All right. Mr. Longston is like, this is the area where I research and advocate. So I am just asking, and thank you. Jen V said, can you explain what a bifurcated case is? Yes, it is just that it is in two parts, that you decide if somebody did a thing first, guilt or not guilt, and then the punishment gets decided later. So there are two parts, and you divide the parts. In every capital case, there is a guilt phase and a penalty phase, where the guilt is decided first and the penalty is decided by the jury after. But when the aggravators or special circumstances or whatever they're called in a jurisdiction, when those get decided can vary. And where those get decided does vary based on jurisdiction. So it's interesting. I'm with the judge. It's an interesting question. So what this counsel is asking for is to do it with 3 instead of 2. Your Honor, we'll do the guilt part first, then we'll do the aggravators second, then we'll do the mitigation, and this is the problem with them calling them aggravators, the circumstances. We'll do the circumstances in the middle, the multiple victims and the utter disregard. We'll do those in the middle. So trial on guilt, trial on the circumstances, and then trial on what the penalty should be. So he's aggravating for 3 trials instead of essentially 2 trials or 2 parts of a trial, which is interesting. But I can see the judge saying, but the Court of Appeals has not evaluated this, so we're not going to do anything new. Thanks, counsel. We'll see what happens in that other case of yours, and then hit me back. Hit me back after that other case. But the judge already indicated that it has been insinuated that allowing for this type of breaking up of the decision making and the fact finding by the jury can be grounds for ineffective assistance of counsel. And because that exists, because that happens, then the court is going to immediately say no. The court's going to immediately say no. If there's any whiff, any scintilla, any LaCroix of this could be IAC, the court's going to say no. Just no. So with that, Ife in the chat asked, and a lot of you have asked throughout the video, and I think court will probably be wrapping up. Isn't this assuming he's going to be found guilty? No, but the defense and prosecution have to prepare for both phases of the trial. They might not get to the second phase, but they have to be prepared for the second phase because it's being asked for. If the defendant is acquitted, then you never get to the second phase. But it takes months to prepare for the second phase, and the same jury decides. So you don't have them decide guilt, say, see you back here in 5 months, and then have them decide what the penalty shall be. So it all has to be prepared beforehand with a if this, then that. And that's how the cases proceed being argued forward.
Thank you, sir. All right, my dance sheet indicates that we have covered all the topics. Did I miss anything from either of your perspectives?
Not from state, Your Honor.
You didn't miss the
No
SAS
motions, Your Honor, but I think
either,
Ms.
Your Honor.
Massa has one thing.
One
Okay.
housekeeping.
Sure.
There's another member of the defense team there. Did I?
Judge, we submitted
Oh, no.
Professor
Sorry.
Cover's PowerPoint and her data. We filed it this morning under seal. We had a conversation that you thought that that should probably not be under seal. Definitely with the PowerPoint, we have no issues there. It was filed with one thumb drive. We discussed letting us look to see if there is victim information that needs to be redacted. So what I'd like your permission to do is file an amended Exhibit A, and if we'll get things redacted. The one that's filed and you are inclined not to seal, I just don't want it to get out there before we've had an opportunity to review that and redact names.
I'm assuming the state doesn't have an objection to that.
No objection, Your Honor. Thank you.
All right, and that's fine, counsel. Let me address, that brings up a good point in terms of just process for filing matters that need to be sealed in some way or the other. Because as we know, the rules for filing require them to be physically filed if you're seeking to have them filed under seal, which causes some difficulty for most of you who are not in the
Immediate vicinity.
Treasure Valley area. I think perhaps the best way to deal with this is if you're going to file something and there's some portion that needs to be under seal, if you would provide
Both.
A redacted and an unredacted copy. So for example, I think the defense filed a recent request for discovery and had an exhibit attached that they felt should be sealed. I'm assuming that's why they requested it to be sealed, was because of the exhibit. So you would file that one with, the exhibit just being a blank page saying redacted, and then provide the court and opposing counsel a courtesy copy of the
Prosecutor's camera was so still, I
unredacted,
thought
and
their
then you
camera
can
was
file
frozen.
Unredacted when you
They're all
are
just like-
here to get it filed under seal. And then we can let the public have the redacted version so that we, as much information as we can, make public we can.
We'll do it that way. Thank you.
That works for everybody.
Thank you, Your Honor.
Else for today.
Lyndon, really?
Nothing else for today.
No way.
There was a motion filed that got placed under seal that the court was going to schedule.
Is that about your jury voir dire procedure? Yeah, I think that's probably more appropriate to take up as we get closer to the pretrial than anything, because it really deals with
Oh, thank you.
essentially what is and isn't allowed in voir dire and in questioning. So
We're a long way
I think
out.
it's just a little early in the game yet to get to that.
There's a lot. There's a
From my
lot of time left on the clock on this one.
Your Honor, the only thought I have about that is perhaps talking about that may cause the court to think we should begin voir dire maybe a tiny bit earlier than is currently scheduled.
Well, you guys are back in January to talk about this,
Well, we can,
and
I
then
think our pretrial is in May, correct?
you have motions in limine in April,
I
and then your
think
final
we can.
pretrial. Your final pretrial conference is
And
May
our
15th,
Voir dire is set to begin in
July
August or
30th.
Late
No,
July, I can't remember.
voir
So
dire
I
begins.
think we have some,
I know. I've got the scheduling order in front of me. Voir dire begins July 30th, 2025. Trial begins August 11th, 2025 through November 7th if needed. The final pretrial conference is May 15th after I go to Metallica. The motions in Lemonade are going to be on April 3rd. This is all going to start to overlap with the Corey Richards trial. We'll figure it out.
flexibility there. And perhaps we'll address it at another hearing before the pretrial. I just thought
January?
with the number of motions we had today, that it was probably something we could
Court's
save for
like-
a later day.
We're going to wait.
Fair enough. Thank you.
There's a lot of motions today.
All right, anything else?
No, thank you, Your Honor.
Can we know where you
So
got
that
your
I'm clear
jacket
on
from?
the
I really like the
record
gray
with respect
jacket.
To why I sealed that. I don't think you submitted that intending it to be sealed originally. The reason I did is because it had in there specific questions that can and can't be asked of folks who are being questioned for voir dire. And because of the extensive publicity here, I don't want to unnecessarily limit our available groups of Venermen because they've read something about what questions to specifically expect to be asked. And so that was my reason for sealing that. Okay. All right. Well, thank you. Everybody have safe travels back. I will take the matters under advisement and issue written opinions forthwith. Thank you.
I'm curious to see what this court's forthwith is, but the judge has taken most things except for the experts who he said he didn't need to testify. The court out. The court has taken those under advisement and will issue his rulings. I very much appreciate the technological setup in this court in Boise. I think the court did a great job with their setup. It's easy to see. I appreciate it, but we are at the end of the end of the motions for today. It was all of the motions regarding the death penalty. Some of these questions may come up again down the road. I imagine that most of the defense motions, if not all, are going to be denied. Bryan Kohberger was there today. He was sitting between his two attorneys. I'm going to do a quick summary, and then I am going to have to go because I have an appointment. But it will be a quick summary, and then I will probably break this down with a bit more thought from me in the quick bits, so I can try, not after 5 hours of court, to synthesize my thoughts. But let's try to do it quickly for everyone in the chat and see if we can just summarize what happened in court today. So at the end of the day, November 7th, 2025, the court went through all of the motions. The earliest motions that were heard today were regarding the defense experts and whether there would be live testimony from the defense experts regarding various motions that were on the docket today, all pertaining to the death penalty in this case. The court had affidavits and a law review article and said, I have those on the record. We do not need live testimony on this today. The record has been made. Most of the arguments were surrounding ways and various arguments on ways to strike the death penalty. So the defense saying, we need to strike on this grounds, we need to strike these aggravators that make it a death penalty eligible case or a capital case, and we need to strike these other things for different reasons. So there are lots of different constitutional arguments and then some policy arguments looped in there as well. At the end of the day, the court questioned the attorneys for both sides very much more like an appellate court. This is definitely not judge's court. And remember, the defense made that motion for change of venue. They got the change of venue, and this is the court that was assigned to the case when the venue changed. He very much directly points to questions for both sides saying, but isn't this true? But where is the case law on that? He is incredibly well-versed in this case, in the case law, and has clearly spent quite a lot of time and energy on the motions that were being presented today. I think this court was incredibly well prepared for both sides and asked pointed, I think appropriately, so not pointed in a bad way, but direct and impactful questions of both sides, which was nice to see. It was not a battle of the wills like we have seen in other court hearings before judge, where at times it seemed that the attorney that could just keep arguing the longest might get their way at the end. This judge was very, very tailored in how he conducted his courtroom and the arguments. I appreciated his questioning. It was insightful. I learned a lot today from the judge's questioning of the attorneys on both sides. But ultimately, the things the judge continued to point out is the standing case law and how to get around the standing case law. And then the other things that the court repeatedly brought up were timing. Aren't these things maybe not ripe yet? Maybe these questions are not ready to be addressed. Remember, there needs to be an ongoing issue. It needs to be the right time. So addressing something too early and ruling on it when all the information is not there is something courts are disinclined to do. I don't like to do it either. It's like, well, I'm going to need more information. And Team Baker is like, Baker, why is it taking you 3 weeks to decide the thing? I'm like, I just need more information. I'm going to need to think about it more. But the defense in this case is preserving their record. If there is a conviction in this case, if it goes forward to a penalty phase, if the jury decides that this is a death case and not a life without the possibility of parole case, then the defense wants to know that they have preserved every possible issue for appeal, and these early trial motions are doing that. It's why attorneys need to be, particularly defense attorneys, qualified within the state to handle these types of cases, because attorneys that have not handled these cases might not even think of some of the arguments to make, where attorneys that have done these cases repeatedly are going to say, okay, these are the motions we are going to make in all of these cases, and we are going to go through them to the court. And even if the court says no, the appellate court down the road might disagree. And what you don't want to have happen is the appellate court down the road to agree with that argument on a different case, but you didn't preserve the argument on your case. And we've seen the appellate court recently this week say, but did that come up at the time? Did the defense ask to do this at the time? Did they do this in court? And look at the attorneys and go, but they could have. And so this is very much a protection against that. And it was nice to see these attorneys make their cases without the type of bickering we have seen in this case in other court. And I think it goes to really the court's approach to this, which is very much no nonsense. But we also saw the court saying to one of the defense attorneys, I will try not to interrupt based on my own curiosity. So we also know that the court is interested in these questions as well. And when the court was not interested, he let counsel know, didn't he? That counsel is falling flat. I think we are going to like this judge. The balance between allowing the attorneys to make their record, not allowing a waste of time, but also not rushing the attorneys and cutting them off. It is a nice balance. He was very well prepared. He's like, do not tell me what you already wrote in your motions. Let's get to the heart of the issue. Let me ask you the questions I have before I rule. Let's not waste everyone's time. This judge came prepared, and I think it's going to move this case along. And I'm optimistic when we get to trial that even when things come up, as they will be dealt with fairly quickly, and that this judge will guarantee and preserve the record. If you go through 3+ months of trial, no one wants this trial to go again. The witnesses don't, law enforcement doesn't, the defense and the defense attorneys don't, the defendant doesn't, the prosecution doesn't, I'm sure the victims' families don't. They want to make sure this case is done right and done once. And so the court is going to allow that. And I think he strikes a good balance with that. I'm going to answer a few questions and then we will move forward. So chat, good to see you. Did you enjoy being in court this week? We need to get back to music court. I owe you a music court. When I put this, I think that the scheduling ruling came out in August or September. When I put it on the calendar, November seemed so far away that I was like, I'll remember to go back and check. And then the law nerds mentioned, y'all mentioned in the chat, hey, are we doing this on Thursday? And I went, what do you mean? Thursday. It's November. What? Somewhere I slipped into a time warp. It's just a jump to the left when we did the Sarah Boone case, and I had no idea what day it was. And then there was actually a time change in Halloween and all the things, and time seemed unreal. So thank you to the law nerds who reminded me. I promise we will get back to music court. I promise. When is always a question, but I promise that we will. For those of you asking where the other prosecutor was, he had asked at the last hearing if he was not arguing the motions, if he could appear by Zoom, and the court granted him permission to do that. So he did. And if you're watching along with the law nerd chat, hi, good to see you. All right, I'm joking, law nerds. A few questions, and then I've got to eat myself and go get the nails done. All right, Sarah. I love hearing this. Sarah said, EDB, I'm going to a Yachtly cruise show this weekend in Thousand Oaks, California. So excited. Have the most fun. Embrace the joy. I don't want to spoil. Have the most fun. Well, you've seen some of the spoilers because I played them in the members only, but have the most fun. They're a ton of fun, and I hope you have the absolute best time. Please keep me in the loop. I would love to hear. Redondo Beach asked if I prosecuted any death cases. I prosecuted special cert cases, but we were not seeking death on the cases that I prosecuted. There's a whole committee. I don't know. Well, who knows what the DA's office is doing at the moment. They are in flux. But before I left, there was a very thorough committee process for that decision. And it was a very long committee process for that decision. But in the cases that I tried that were special circs, that was not the penalty that we were seeking. So no, I did a lot of, and really leaned in a lot to fraud cases, computer crime cases and stuff like that. Not that other cases aren't important, but shockingly, not everyone is a nerd for cases that involve, reams of paper like I was. So there were lots of prosecutors that were like, I'll do all of the violent crime. And I was like, but did you see what is in their computer search history? So, Chris asked in the chat, isn't multiple victims inherently aggravating? So aggravating in the common use of the word is not what we are talking about. We are talking about an aggravating factor as a legal term of art in this context. And in this context, it is, and this is why I like that California calls them special circs, because there are both the circumstance that can change a case, and then there are the aggravation and mitigation down the road that can change a case. And when you call everything aggravation, it gets very confusing, I think, but I didn't write the laws in Idaho, so, it is what it is. But no, the jury has to find it because it is one of those circumstances the jury can find if the district attorney seeks to ask for that. So no, not every case where there are multiple victims will be a case where there will be a filing asking to seek to make it a capital case. So not every case where there are multiple victims would be a case where this would apply. But in the common sense of the word, yes. But, legal term of art, hopefully that helps. Evil Oddish, good to see you in the chat. My 2-pack tumbler special just arrived. I'm so glad that you enjoyed them. They're cute. Look, I am so thrilled that we were able to make our own little Law Nerd cutout. But remember, these are going away when Law Nerd Shop version 1.0 closes on Friday. So if that is something that you are interested in, make sure you head to the Law Nerd Shop, because Law Nerd Shop 1.0 is closing. Law Nerd Shop 2.0 is opening later this month in time for the holidays. Laura asked, is there a smaller version of the tumblers? No, these are the tumblers. We have other drinking accoutrement in the store at the moment, but the tumblers are one size only, mostly because all things physical goods is a thing. Also because these are my favorite size. So when faced with we can do one thing, I defaulted to my favorite size. Flightless said, when is the next case? How soon is now? Thank you for your coverage today. I don't know when we are back in court again. I'm going to have to update the docket for me. So I don't know. Oh, that is my timer. Like, girl, you've got things to do today. No. As my device is going to try to play music that will invariably be a problem. Don't do that. Don't do that. Thank you, Casey Cat, for the gifted memberships on your birthday. I appreciate it. J. Michael, I'm so glad you got your order. They are absolutely shipping in a timely fashion. Let's see. I'm going to see if there are any other questions. Becca said, why are they arguing DP if he hasn't been convicted? Are they arguing whether the trial will be Yes, Becca, you do. This is a good question. And many were confused because it's like, why are we talking about this now? We're talking about it now because they have to decide how the trial is going to go forward. They need to know what the jury's going to have to consider. These are all considerations that are argued kind of as a if then. So it's not saying that this has to happen. It's saying if then. So the if will be the penalty or the guilt phase. The then is a penalty phase. It has to be prepared for before you get there. So hopefully. Michelle L. said, definitely reminds me of the Karen Reed oral arguments back and forth with the SJC justices. I enjoy this part of the law. Judge is great. It is. It is very much an intellectual exploration of the law and the rules and what they are. And then you heard argument today of what they should be. And you heard that in the Karen Reed case too. It's like, Your Honors, at the end of the day, shouldn't it be this way? How can it be justice if this isn't the result? So you get a bit of both, but it is in a more level way, if that makes sense. So it is a very analytical approach to everything, which is why, again, lawyers are just like, lawyers can be completely analytical about everything. And there's times when my husband will say something, I'm like, do you mean this, or this? And he's like, are you cross-examining me? I'm like, no, I really just, what do the words mean? How do you mean those words? Because I need to understand how you mean those words. And then I'll let you know if I'm cross-examining you. So it is just how lawyers think. And when you get into that mode, especially if you're in trial a lot, it's hard to get out of work mode. Kadora 1090 said, thought we could use a funny editing a Q&A transcript for school while joining live. I hear EDB and goat scream every time I read on transcript, what if anything? On page 25 of transcript, we're at 27, what if anything? Oh, sometimes it's really nice when attorneys just pause and ask shorter questions. Look, there is a lot of value when questioning to keep it simple. If you keep it simple, the manner of how things can mean different things is different. And when you look at the appellate court and you look at the questioning of the judges, looking at the transcript being like, but this is what happened. The shorter the questions are, the better their clarity is. And so you see the argument of the judges and the attorneys in the Karen Reed case saying, okay, but what does the word charges mean? Does charges mean count 1, 2, and 3, or does charges mean count 2, subparts A, B, C, and D? What is the meaning of the word charges? So the more you can limit those types of conversations about what the meaning of a particular word meant in that context in court on a transcript, the cleaner it will be for everyone. And I think if lawyers do not do a ton of trials, then it can be hard when you get into the default of everything starts with what if anything. There are times where it is really the appropriate thing, but I think those times are limited. When, if any, time is appropriate. When it is a limited time and a limited use. Law nerds, it is time. We have been here for like 5 hours. We've done 2 5-hour streams this week and an early morning pajama court stream yesterday. Team Baker and it like hour plus podcast. How many hours of Emily have we put out this week? Oh, and I was on Vial Files this week, and I have a podcast with a friend dropping tomorrow too that I will let you know about in the Law Nerd app. So there are so many hours of Emily this week. Emily needs a nap. Law Nerds, you probably do too. I forgot to feed my Snorlax this morning, but with all of that, it has been lots of coverage. I will be back with you with Quick Bits on Monday. If you are not subscribed to Quick Bits on the channel yet, you can do that either on the channel or those episodes come out on the audio, the Emily Show audio on your favorite podcasting app. So you can download it there too. The cut downs, the Quick Bits episodes or the Monday episodes come out there. Can I even call it quick anymore when we're like at 30 plus minutes every week? The multi-story episode, the Monday show, that is coming out this week. And I will say, as we get into next week is going to be the 5-year anniversary of the podcast. If I had never started that podcast, I never would have started streaming on YouTube. So I'm very excited to chat a little bit about the 5-year anniversary of the podcast and what's coming next in 2025. And as you've guessed, that includes a fuck ton of trial days, because this one, August to November, I'm contemplating buying a stand desk so I can stand up during trial. I don't think I can sit for that many days. I think I'm contemplating a stand desk for that trial because it's going to be so long. The trial schedule, at least it doesn't cover all of the concert season. So y'all, we're just gonna be here for a lot of trial. We've got a lot of trials coming up. With all of that, Law Nerds, you're the best. It's good to see you. I appreciate spending this week with you talking about all of the court things. It is wonderful to be in community with the humans who I enjoy seeing so much in the chat. I hope you've enjoyed being with each other this week. And I will see you soon, Law Nerds. Don't forget to get the app. Don't forget to hit the Law Nerd Shop before it closes. And we'll be talking about Law Nerd Shop 2.0 very soon. All right. And today we did have a sponsor. So thank you to our sponsor. The links for Foreo are all down below if you want to grab that discount. It is all linked below. So thank you to our stream sponsor and thank you to all of you. I will see you guys in the next one. Bye.
You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.